I'm gonna copy these. Alright, I'm gonna go down and copy this.
We can leave our bag on the bed. Yes, I'm sorry. Hey, Holly. Okay. So you have to not try not to keep it. You were going to go back.
Hey, how you doing? Oh, yeah.
Okay. Well, let's go away.
Where you guys sitting?
We should be able to make it without that. Like,
Okay, good enough. All right.
if we just do this, it should go through. I hope. But I'll let you know.
Yeah, because I'm still going up on the cloud.
Perfect. Love the cloud.
Nice. What color? Already? Yeah, I'm very fine. I was in the courtroom.
Not in here, out there.
It's over there. My neighbor. Clean up this here a little bit. All right.
Yes. Thank you. Thank
Everything good? Yeah, I just need to. Oh, you got some luck up for lunch. You got all right before we extend it. Okay, all right. I'm gonna run downstairs. That's all I'm doing. What else? Something else I was going down there.
can't agree that the documents that are not in the certified bundle are properly admitted as part of the exhibit.
Okay, Ms. Merchant, would you like to repackage and present to Ms. Cross Defense Exhibit 14?
They're exactly what I got from the county attorney. Apparently, they didn't want to testify, so they gave us a certification but didn't put these in, so they're going to have to testify. I got them from them.
The documents that, the difference between the two document productions, what is the difference?
They didn't
Bank
even give
records,
these.
bank records, credit card statements, things like that that wouldn't ordinarily be part and course of the Fulton County records.
But I got them from the Open Records portal, so that's where I printed them.
No, I understand. But the difference in production, Ms. Merchant, you've taken a look at them and they're actually material to your case?
Yes.
In what way?
They're all of his invoices, Judge, and then he has this is what I got from them. It's all of his invoices, and one of the invoices is a reimbursement that he printed some things, but for the reimbursement. I don't really care if they take the reimbursement out because they actually are already admitted in the other exhibit I did.
I don't have any problem with the invoices. The invoices are clearly the records and contained in the certification. So if we remove the items that
They're already
are in dispute, then I don't have an objection to that.
They're already in exhibit.
So you're removing them?
Yeah, that's fine. You want to take them out?
All right, so again, let's have opposing counsel look at a revised Exhibit 14 and then I'll hear whether there's any objection.
The revised exhibit number 14 contains only the invoices that were submitted, and the state has no objection to that.
All right, then, not seeing any other issues from other counsel, we'll note Exhibits 14 through 18 have been admitted for the record without objection.
Didn't care.
I think at this point, it'd be good to make sure we've got, 1 through 18 with the court reporter.
Others, but do you want me to give them to the witness?
Let's, if he's done looking at them, let's just get them all compiled and organized and with the court reporter in case other defense counsel are going to reference them. No, it wasn't for him to have them all. We just need to have 1 through 18 organized
sorry.
with the court reporter. Yeah.
So you want me to take all the exhibits back from him?
I think we ought to do that.
I will do that. Thank you.
Yeah.
That's not.
This is
Okay.
all right. As Ms. Merchant is doing that, let me go down the list. Mr. Sadow.
Your Honor, if the court will permit, Mr. Gillen is going to ask some questions that I was going to ask. I'd like to be able to just follow up if there's anything that he doesn't touch on. Is that a word?
Let me just to keep it consistent, I'll go in order. So if Mr. Sadow is deferring, then I'll go to Mr. Stocks,
I would defer to that.
Mr. Durham on Zoom.
No, Your Honor.
All right, Mr. McDougald.
I will defer to Mr. Gillen.
All right, Mr. Rice. All right, thank you, Mr. Gillen.
Thank you, Your Honor. Good afternoon, Mr. Wade.
Good afternoon, sir.
A few follow-up questions. I'd like to start off with the exhibit number 4 that you should have up there. Those are the interrogatories.
No, sir.
They're not up there?
Remember, I asked her to compile them all, so
I'm
now you
sorry.
can grab
Right
them.
here, I'm going to give it to you if you wanted me to come in.
Yes, sir.
Okay. Now, these are the interrogatories that you had filed on May the 30th, 2023 in your divorce case, correct?
Yes, sir.
Now, you went over in part some of those interrogatories, but what I want you to do, because I want to get down to the specific language to clear up exactly what the interrogatories asked for and exactly what you answered, okay?
Yes, sir.
Now, if we look on the interrogatory that I believe, as we indicated, they're really, I think, on page 2, the one that starts off, describe each instance in which you've had sexual relations. You see that one?
Yes, sir.
Right. Now, that interrogatory begins, describe each instance in which you have had sexual relations with a person other than your spouse during the course of the marriage, including the period of separation. You see that?
Yes, sir.
Now, these were filed on May the 30th, 2023, correct?
Yes, sir.
Now, at that time, you had had sexual relations with Miss Willis, correct?
Well,
Your Honor, I'm going to object to the question as phrased. I think the question is properly, at that time, certainly asked about his answer, but I object to.
All right, Mr. Gillen, I just ask you to rephrase, but I think you can make the same point.
Well, Your Honor, it's a specific interrogatory, and I would, so the words do matter, and I would like him to answer whether or not he'd had sexual relations with Miss Willis, because if he answered yes, then this interrogatory is a false interrogatory. So I would ask the court's indulgence. I'm not here to jump into some salacious bedroom situation, but this is an interrogatory that matters. So I would ask the court's indulgence.
Ms. Cross?
These questions have been asked and answered several times. I understand Mr. Gillen is coming at it from a different way, but this question is not substantively different than those that have already been asked and answered in the information that he is seeking.
All right, Mr. Gillen, I'll allow maybe this question and one more, but I think you are asking it in a different way, and I'll ask you to stick to the point.
All right. Now, as of May the 30th, and may I ask the question that okay, thank you, Your Honor. As of May the 30th, 2023, you had had sexual relations with Miss Willis, isn't that correct?
the interrogatory, sir, asks during the course of the marriage and the period of separation.
Excuse me.
My response,
Your Honor, I would ask that the court direct the witness to answer my question, yes or no. As of May the 30th, 2023, had you had sexual relations with Miss Willis? Yes or no?
Mr. Gillen, let's start with at the higher level whether he believes he answered it truthfully, and then we can drill down into why or why not he doesn't, and maybe we'll end up exactly where you left us.
Well, but again, Your Honor, the point of it is that the words matter, and that we have to establish what did and did not happen, and then he can give whatever explanation he chooses to what apparently is a false answer. But I would like an answer to my question.
And you may get one. I would like us to start at the high level before we drill down into specifics to see whether he actually contradicted that interrogatory, if I'm making sense.
Well, the interrogatory is relatively direct and explicit. Sexual relationships with a person other than your spouse during the course of the marriage, including the period of separation. That's pretty simple.
Sure. Let's see if that's something you can get him to admit.
You did have sexual relationships with someone other than your spouse during the course of the marriage and during the period of separation, which included up to May the 30th of 2023. Isn't that correct, sir?
My answer to this interrogatory is none. Is no.
So you're saying that you did not have sexual relationships with anyone outside of your marriage, and the period of separation is during the period. Then you're answering the question to this interrogatory, correct, sir?
I'm saying during the course of my marriage, I did not have sexual relations to anyone, and this answer is no.
Well, again, Your Honor,
I understand. You can proceed, Mr. Gillen.
We need a yes or no. Let's just get down to it. Did you or did you not, by May the 30th, 2023, have had sexual relations with Miss Willis, yes or no? Yes or no?
Yes.
Okay. Now, what you did is you answered no to that question, didn't you, or none, correct?
I didn't answer no to the question you just asked. I answered no to the interrogatory question.
And the interrogatory stands that you answered as a pleading in a civil proceeding, your divorce case, right?
Yes.
Now, excuse me. The next interrogatory, let's move there. That interrogatory states as follows. Identify any and all occasions in which you entertain a member of the opposite sex other than your spouse who is not related to you by blood or marriage. You see that?
I do.
Now, there are two parts to this. The second part is, I read on, or in which a member of the opposite sex other than your spouse, not related to you by blood or marriage, entertained you. And then it goes on to say, including but not limited to dining, drinking, in restaurants, bars, pubs, hotels. You see that, correct?
I do.
Now, as of May the 30th, 2023, when you filed this interrogatory, you had in fact entertained Ms. Willis on many occasions, had you not?
Again, during the course of the marriage was irretrievably broken in 2015.
Well,
the answer's still no.
Let's read what the interrogatory says about the time period required to answer the interrogatory. Because what it says is, it goes on to say, including but not limited to dining and or drinking at any restaurants, bars, pubs, hotels, or persons' homes from the date of marriage to the present. You understand what the word present means?
I do.
And present means the filing on May the 30th, 2023. Isn't that right?
It is.
So as of May the 30th, 2023, you have done a lot, or you had done a lot of entertaining of Miss Willis, had you not?
I had done some, yes.
And in fact, under your testimony, you would have said that she had also entertained you. Isn't that correct?
Yes.
And so your answer to this interrogatory is false, is it not, sir?
No, it's not false.
Well, hate to dance around the. The answer is yes, you did entertain Miss Willis, correct? Right?
Yes.
She's not your spouse at that time or at any time, correct?
That's correct.
She's not related to you by blood or marriage, correct?
That's correct.
But you entertained her, right?
Yes.
And during the course from your marriage, the period of time up to the present, so the answer would have been, yes, I did entertain somebody, correct?
During the course of the marriage, no.
Mr. Wade.
Mr. Gillen, I think we've made our point. I think it speaks for itself, and we can save that for argument.
I'll just follow up with one quick question. Do you understand what the word present means?
Your Honor, that's been asked of us.
I think we did cover that already as well.
Okay. Now, what has happened from the time that you filed this court document in May of 2023, let's go over some of the things that you had been involved in terms of being entertained or entertaining. Prior to your filing on the answer on the interrogatories on May the 30th, 2023, we've already established, have we not, that you had paid for a Royal Caribbean cruise to the Bahamas with Miss Willis, correct?
Yes, sir, with Miss Willis and my mother.
Well, your mother's not a part of this interrogatory. I'm talking about Miss Willis, okay? So you paid and caused to be paid approximately $3,335 on that trip, Bahamas trip, from October the 28th through October the 31st, correct?
Your Honor, objection. I think we've touched this ground several times already.
Mr. Gillen, let's cover new ground.
Well, I'm just trying to establish with specificity the things that he had done to entertain or be entertained prior to May the 30th, 2023. I'll try to move through it quickly.
Sure. Well, that's already part of the record in terms of his prior testimony, and so if you want to link those two things together, you can do that during argument.
Well, so let me discuss this. You indicated that during the course of your explanation concerning the Belize trip, that Miss Willis paid you all that money back in cash. Remember?
Yes, sir.
Now, the Belize trip had just happened, hadn't it? That occurred in March 18th, 2023, right?
Yes, sir.
So you're filing this maybe 2 months after you have gone to Belize with Miss Willis, correct?
Your Honor, again, I believe all of this is
I think you might be getting somewhere new. We'll see.
All right.
Yes, sir.
So we've got the trip in to Belize on March the 18th, 2023. You and Miss Willis, correct?
Yes, sir.
Now, 2 months later, you file the interrogatories that speak for themselves that we've gone over a few minutes ago, correct?
Yes, sir.
Now, the March the 18th, 2023, to state the obvious, is before May the 30th, 2023. Will you agree with me on that?
I do.
Okay. So then you tell us that Miss Willis paid you in cash all the money for the entire trip. It was a gift for you for your birthday, correct?
Yes, sir.
And I'm sure you probably have the deposit slips where you took the cash and deposited the cash into your account, don't you?
I did not deposit the cash in my account.
You don't have a single solitary deposit slip to corroborate or support any of your allegations that you were paid by Mrs. Willis in cash, do you?
No, sir.
Not a single solitary one.
Not a one.
Now, when Miss Willis would pay you in cash, would you scamper down to the ATM with her, and as she drew money out of her account
Your
to
Honor.
pay you these thousands of dollars?
Mr. Gillen might scamper, but there's been no evidence that Mr. Wade does. I object to the phrasing, the argumentative nature of the question.
All right. On that issue, overruled.
Did you and Miss Wade scamper down to the ATM machine and have her draw out, for example, on the Belize trip, just on your payment would have been $2,794?
Miss Wade,
For clarity, yeah, thank you.
Pardon me?
Miss Wade and I didn't go to Belize.
No, excuse me, Miss Willis. I'm sorry. Did you go down to the ATM with Miss Willis while she drew out $2,794 to pay you in cash? Did you go to the ATM with her?
No, sir. She didn't go to the ATM. She carried the cash.
Oh, and so she would give you the cash. Did you have a little place in your house where you just stack up all this cash that you apparently got to repay you for these benefits that you bestowed on her?
Now, Mr. Gillen, if I answered that, I'm putting myself in jeopardy. If I tell the world that I have cash someplace in my home, don't you think that could be problematic?
No, I don't. I want an answer as to whether or not you have a little cash hoard in your house where you have allegedly taken the money that you got from Mrs. Willis and went and put it somewhere. Where'd you put it?
No, sir.
Now, just put it on the hip and kind of walk around money?
Did I put it on my hip?
Yeah, just walking around money where you would spend cash yourself?
Let me finish. Did I put it on my hip in Belize and walk around with
No,
it?
when you got paid back, would you take the money, the cash that she gave you, and would you just carry it around with you for spending money around town?
So we have to break down each trip because, for example, for the cruise, she paid me the money before we took the cruise. So I was here and I could put the money in my pocket or put it away wherever I wanted to do with it. Other trips, she would give me the money there. So at that point, I could either spend it or put it in my pocket or put it in the hotel safe.
There's no special place that you would have all this cash that you would be getting from her that you've told us about to pay back for the benefits that you have bestowed on her?
The only special place that cash would have gone would have been to one of my children.
Okay. Now, are you aware, have you discussed these pleadings with Miss Willis?
No, sir.
So there's been no discussion between you and Miss Willis about the allegation concerning the benefits that you have bestowed on her. Is that correct?
For the phrasing, the benefits bestowed upon her, I don't believe that's an accurate reflection of the testimony, and I don't think that's appropriate.
I think overruled. You can answer the question.
Okay. When you say proceedings, are you talking about the divorce proceedings? Because we were talking about the interrogatories. To that question, the answer is no. If you're go ahead.
I'm sorry. Go ahead with your answer. I'll hear the complete answer, then I'll follow up.
Okay. If you're asking me about this hearing, the proceedings of this hearing, have we discussed the financial piece based upon Mr. Roman's motion? Yes.
So you have discussed the financial piece. Where did that discussion take place?
Conference room.
Were you other people there, or were you and Miss Willis discussing this about what your position was going to be.
The relevance of this.
Well,
Mr. Gillen?
and the relevance has to do with suddenly we have a declaration from Mr. Wade in this case where he says roughly equal and then shows one alleged payment by Miss Willis. No mention of cash, none. So I need to find out a little bit more about how suddenly we have this revelation about cash from the witness stand today.
All right. Overruled.
So we part company there when you say no mention of cash. If I provided one receipt that didn't amount to what you would think was roughly equal, the rest of it is cash.
Well, did you in your declaration, sir, it was filed in this case, did you tell the court in that declaration that the expenditure that you had provided on behalf of Miss Willis was paid for back by her in cash, yes or no?
I believe that I did when I said that the expenses were split roughly evenly.
If you could point to me any place in your affidavit where you used the word cash, I would appreciate it. Take your time.
I didn't use the word cash, no, sir.
No, you didn't use the word cash, did you?
But I didn't say that she didn't give it to me in cash.
No, you just didn't tell anybody that you allegedly got paid back in cash, right?
No, I told everyone who asked.
Today.
Yes, sir.
Now, who else was with you, if anyone else, when you and Ms. Willis were discussing how you would be handling the financial component of the motion here today, that is the personal benefits?
I'm going to object to the relevance of that, Your Honor.
Mr. Gillen?
Well, the relevance is if they know that they're going to be called as witnesses, they've been subpoenaed, and they are discussing what they're going to say, we need to know that. The court needs to know that. It goes to the veracity of Mr. Willis and, Miss Willis and Mr. Wade.
Overruled.
We didn't discuss how we were going to handle testimony.
My question was, when you were discussing with Miss Willis in the conference room, when you were discussing what you perceived to be the situation concerning the benefits for the payments.
Yes, sir.
Was there anyone else present?
No, sir.
How long did the meeting take?
Probably 5 or 10 minutes.
Did Miss Willis tell you what she was going to say?
No, sir.
Did you ask her whether she had any bank withdrawals that would corroborate the assertion that she would pay you back in large sums of cash for these trips to the Caribbean, Belize, California, on and on and on?
Your Honor, again, I object. The proffer when the last relevance objection was made was that Mr. Gillen needed to know who else was there, these could be potential witnesses that he could cross-examine. That question has been answered, so I do not object.
Okay. I think it's still exploring possible bias or motive to shape his testimony, so overrule on that ground.
Thank you. Now, Mr. Willis, Mr. Wade, when you were having this discussion, did you ask Ms. Willis, do you have anything to support these cash withdrawals?
No, sir.
Did you ask her where she got the cash?
Here, this is the conversation. I produced my credit card statement that showed what Miss Merchant in her filing was representing. That was the conversation.
Okay. So when she would pay you back in cash, were you aware of what her financial situation was? Do you know what?
No, sir.
Your Honor, I object to the relevance.
Well, Your Honor, it's relevant because we've been bombarded with the book, Find Me the Votes, in which...
What's at issue is the financial benefit, and if that plays a material interest in an actual conflict of interest, so I think that's relevant.
Thank you. Now, have you read the book, Find Me the Votes?
I have.
You have?
I have.
Okay. Now, in that book, Ms. Willis is telling the authors about how financially destitute she was, or kind of hitting down on the bottom as she was running for DA. Do you remember that part of the book?
So let me qualify the response. I've read the book in parts. I hadn't had the time to sit and read the book in its entirety.
Did you read that part about how she's telling the authors about how little money she had and how financially she was in bad shape prior to when she was running? Did you read that part?
No, sir.
Did you ever have discussions with Ms. Willis about her financial situation, which was in apparently in rough shape prior to her being elected DA?
No, sir. Ms. Willis made it clear that her financial business was just that. It was her business. I know nothing about her financial status. I know nothing about how she was faring before or after the election, or even now. I know nothing about her finances.
Telling us that she didn't share that with you, but chose to share it with the authors of a book that's been published and printed and sold nationally.
I think that's a fair question for Cross.
I don't know that she shared it with the author. I don't know that the author is telling the truth. I don't know the author, so I don't know, sir.
Okay. Now, did you give an interview to the authors of that book?
I've given no interviews, sir.
So you haven't talked to them at all, correct?
I haven't talked to any media.
All right.
None.
Now, as it relates to the...
I'd like to, though.
As it relates to, again, from your bank records that you're aware of, there'll be no cash deposits, right?
I didn't say that.
Are there cash deposits which line up with the money that you have allegedly received from Ms. Willis to, quote, pay you back for her part of the trips?
So here's the thing. In my bank records, you will see cash deposits. You will see check deposits. I can't say that you look through the bank records and you won't see cash deposits, because I have two sources of income, sir. Income comes from my private practice, my firm, and income comes from the contract here with Fulton County. During the course of private practice, occasionally I will have occasion to deposit cash into my account.
And in preparation for this hearing and your testimony, did you go through your bank records to find out if you could locate any cash deposits that would corroborate your testimony?
No, sir. I didn't go through my bank records at all.
Now, so what you would do, the money that you received, of course, the money that you received from your work for Fulton County, that's public funds, correct?
No, sir. That's private funds. It's my
public funds pay you to do work for Fulton County, correct?
Tell me what the definition of a public fund is.
A public fund would be funds, as in not fund, but funds, money. Public money, as in money from taxpayers, either in Fulton County or the state of Georgia, pay you to do the work that you're doing here in this case, yes or no?
One or the other, I'm certain.
You know which one?
The case. I don't know which one, no, sir.
Now, you would take those public funds, and those public funds were then used, deposited in your account, and they were then used to pay on the credit cards for the trips that you would take with Ms. Willis, correct?
I object to the question insofar as the characterization of public funds. The witness didn't testify to that, and I don't believe there's been any evidence to that. Once it's paid to Mr. Wade, it's private funds.
Well, the point of it is that you got money.
All right, Mr. Gillen's rephrasing.
Yeah, I'll rephrase. Let's break it down. You got money from Fulton County for the work that you do here, right?
Yes, sir.
You would send in invoices, and they would pay you money, correct?
Yes, sir.
Those money, that private money, that money was money from either the citizens of Fulton County or from the state of Georgia, correct? That's what I mean by public funds. Agreed?
Well, I guess I'm having trouble with the notion that the citizens of Fulton County have paid me any funds. I'm not certain the funding source. I can tell you that either the state of Georgia or Fulton County has written me a check.
So that would be those two entities are public entities, correct?
Yes.
So that would be public funds, right? Right? Yeah.
Yes.
And those public funds are from the same source that you would then use to pay out on your expenses for the trips that you took Miss Willis on, correct?
No, sir. As I testified to moments ago, I have income coming in from my law firm. I also have income coming in from the funds that we're here discussing now from either the state of Georgia or Fulton County and or both. I'm not certain what it is. So
What
to
percent?
say
Sorry,
that
I didn't mean to
that
cut
I'm-
you off. Go ahead.
So to say that I'm paying a credit card statement with funds coming from Fulton County or the state of Georgia would not be an accurate statement, because the funds could have very well come from my private practice.
What percentage of your income in 2022 came from money where you're working on this case or from your partners working for the Fulton County office?
In 2022, I would say 50-50.
You think 50-50 in 2022?
Yes, sir.
What about 2023?
Probably 60-40.
60-40.
Yes, sir.
So the money that would be in those accounts, at least 60% of those, in your view, would be public funds, that those monies were then used to pay for the expenses that you had incurred for the trips that you took Miss Willis on, the cruises, the Napa Valleys, the Bahamas, correct? Right?
Yes, sir.
Okay. And now, what you did is that when you signed on in November 1st of 2021, that's when you signed on to be counsel for the anti-corruption matters, right?
Yes, sir.
Now, as you know, in your engagement letter, it doesn't say that you're signing on and your scope of work is to work on the Trump special grand jury investigation, does it?
No, sir.
It says that you're signing on to work on anti-corruption, the anti-corruption unit matters, correct?
Yes, sir.
Matters with a plural, correct?
Yes, sir.
So in your contract, there is no specific reference to any specific case. Isn't that right?
That's correct.
Okay. Now, but you didn't sign on for the duration. There was a period, you have a contract, and then it would then expire, and then you would have a new contract, correct?
Yes, sir.
Now, of course, the extension that you received, the first one was in November of 2021, and then you filed, or excuse me, there was a renewal in November the 15th of 2022. Is that right?
Sounds right.
Oh, okay. Now, that was right after you got re-upped by Miss Willis, right after you took Miss Willis to Aruba. Isn't that right? On that November the 1st, 2022 trip to Aruba, and through November the 4th, 2022. Correct?
What does re-up mean?
Well, re-up means that you came back, your contract was up, and then on November the 15th, you and Miss Willis signed a new contract for you, right?
Yes, sir.
Okay. Now, when you were in taking her to the Aruba and on the cruises and the resort there, did you discuss your re-upping of signing an extension on your contract?
No, sir. But you make an excellent point. I'm glad you pointed that out. So the trip to Aruba, the contract was not in existence then.
So you're saying that you were not
under contract.
In your contract. Did you send any invoices in for work that you did after your first contract expired?
No, sir.
You didn't?
No, sir.
So when that expired, that was it. So then you're saying that after the Aruba trip, you get re-upped with a new contract, correct?
I signed a new contract, yes,
Now,
sir.
was there any modifications on that contract? Did you get an extension on the cap that you were limited on the first one? Were there any modifications at all, Mr. Willis? Excuse me. I've done that again. I apologize.
I've been called worse.
Wait, I'm sorry.
I've been called worse.
Now, were there any modifications on that?
Do you have the contracts in front of you where you could?
I don't have it in front of me, but I think that Birch is going to.
Because I believe as the work gradually, as the time of the work gradually increased, the hourly cap would increase. In other words, starting out the investigation, it was impossible to anticipate the level of cooperation during the course of the investigation from some of the witnesses. So if you assume that there would be great cooperation with the witnesses in terms of interviewing and speaking and being voluntarily speaking with you, it doesn't take as much time. So after getting into it, realizing that most of the witnesses were not willing to speak or willing to turn over evidence or information, quickly you figure out that this is going to take a little more time than originally anticipated. And because of that, you have to compensate for those hours.
And that's why there was a compensation on your extension?
Yes, sir. The caps.
A cap. Now, did Mrs. Willis, did Miss Willis review your invoices with you when you would submit them?
Never.
Did anyone ever question whether or not you worked 24 hours in one day and billed 24 hours in one day?
I've never worked 24 hours in one day and billed 24 hours in one day.
Okay.
And I'm glad you asked me that question because I'd like the opportunity to talk about that.
I think you should. Go ahead.
So, if you look at that invoice where it says 24 hours in one day, it actually doesn't say one day. If you look at the top of the invoice, it says date completed. The date that's reflected on that invoice reflects the date that the work was completed. It doesn't say when it started. It just says this is the date that is completed. So if you go through the invoices, probably around the first 5 or 6, you'll see that that's the billing format. I would bill only after that particular task has been completed. That's why you see a 24-hour period with the one day there. I kind of wish some of the experts who had opined on that had called me and asked me the question. But there was never a billing of 24 hours in one day. Now, probably around the 6th or 7th invoice, you see the format changed. I started using a range so that it got less confusing, right?
I'm confused, so maybe you can correct it.
Okay.
In Exhibit 14, you've got down a specific day.
Mm-hmm.
Prepared cases for pretrial, November the 5th, 2021, 24 hours at $250 an hour, 6,000. No, this wasn't about a range. It was about the work that you did on November the 5th, 2021.
No, Mr. Gillen, look at the top of the invoice where it says date completed.
Yeah, what I want you to do, Mr. Wade, is focus on the date that you have down there and tell the court what you billed for on November the 5th, 2021. I thought it was already in. I thought 14 is in.
Again, Mr. Gillen, it says completed date completed. The dates that you see here are the dates that work was completed. So on November the 5th, I completed the task of preparing the cases for pretrial. That's the date I completed it.
Just read, if you would. Then my question was, read out loud the entry for November the 5th, 2021, and how many hours you billed that day. Just do that for me, if you would.
I can't do that.
Excuse me, I believe the witness is entitled to answer his question. That certainly wasn't the question that Mr. Gillen asked him.
All right, well, the question now is to read a certain entry. So
I just read into the record, Mr. Wade, on November the 5th, 2021, how many hours did you bill the citizens of Fulton County for on that day? Just read it out, please.
I completed the task on November 5th, 2021. 24 hours was billed at $250.
Now, when you talked about your relationship with Ms. Willis, and your testimony is that it began in 2022. You remember that testimony?
No, sir. Our relationship began in
Your
2019.
romantic relationship began in 2022? Is
Yes,
that
sir.
That's
Yes,
your
sir.
testimony?
Yes, sir.
Okay. Now, when you were re-upped on this contract, you had a romantic relationship already established with Miss Willis, yes or no?
In 2022?
You know, when
Yes,
you were
sir.
re-upped on November the 15th, 2022, you had a romantic relationship with Miss Willis.
I signed the second contract. Yes, sir.
Answer my question, please.
I'm not going to use the words re-up.
Signed up on the we re-up or whatever you want to call it, your contract on November the 15th, 2022, you had a romantic relationship already existing with Miss Willis, yes or no?
I signed the contract, the second contract, yes, sir, during the course of a romantic relationship.
Yes or no, you had a romantic relationship with her at the time that you signed up the extension on November the 15th, 2022, yes or no?
The answer to that question is yes.
Thank you. Now, this was before the special purpose grand jury released a report. Isn't that correct? Correct?
Are you asking me if it's before the work was completed or before the special purpose grand jury actually publicly released the report?
When they
Those are
released
two
the
different.
report. Your relationship with Miss Willis already existed when the special purpose grand jury released its report, correct?
At the time the report was released, yes, sir. But
And-
you understand that the report, the work had been completed prior to the release of the report. You understand that?
And your relationship with Miss Willis, of course, was prior to the indictment in this case, correct?
Yes, sir.
Your Honor, if I may just ask my folks over here whether there's anything I need to clean up on. That's all the questions, Your Honor, I have. Thank you.
Your Honor, I do have questions.
Well, Mr. State, I think we went through.
No, I had asked you for permission, but he was going to go first on this, and then I was going to follow up. That's the deferment was to allow him to go first. That's what I thought I had asked you for.
All right, with the understanding next time, we're going to keep going in order and not skip around the order. All right.
That's why I brought it up, because I thought that's what.
Okay. All right. Mr. Sato.
I'm going to try to keep my questions very specific.
Yes, sir.
Okay?
Yes, sir.
And I'm going to also, of course, try not to go back into specific questions that have already been asked. Okay?
Yes, sir.
When did your relationship with Miss Willis end?
2023.
Can you give us an approximation of, not by date, but by month?
Summer 2023. Forgive me. I'm a man. We don't do the date thing. Summer 23, I would say June, maybe.
Okay. Using the euphemism personal relationship, did you have any personal relationship at all with Miss Willis after the summer of 2023?
I want to make sure that I'm answering your question. Are you, because
Let me rephrase, if I might. The way it has been characterized in, for example, the response of the state, and I believe in your affidavit, is there's a difference between a personal relationship and a professional relationship. Correct?
yes, sir.
Okay. I'm not talking about a professional relationship. I'm talking about a personal relationship. Have you had a personal relationship at all, and you know what I mean by that, after the summer of 2023?
Are you asking me if I had intercourse with the district attorney?
I was trying not to, but I guess if you're going to characterize it as that, the answer would be?
The answer would be no.
So it's been purely professional since the summer of 2023.
So that's where we're having issues.
Okay, you'll have to explain, because I don't know what the issue would be.
No, I will explain to you.
Thank you.
You say personal. We're very good friends, probably closer than ever because of these attacks. But if you're asking me about specific intercourse, the answer is no.
How about if I change it from intercourse to romantic?
No.
Okay. During the direct examination, you made a statement, at least I believe I heard it correctly, that personal relationship, and now I'm talking about that characterized the sexual romantic relationship, was not a secret. Is that correct?
Wait. If you're asking me if people knew that we were having sex, no, they didn't.
I'm asking you whether the people knew that you were dating, whether you were romantically involved. You said that it was not a secret.
Oh, it wasn't a secret. It was just private. My mother knew, obviously.
Okay. Did anyone in the district attorney's office that has worked on this case know that you were dating or had a romantic relationship with District Attorney Willis?
I don't know what they knew.
Well, did you tell anyone?
No.
Do you have any knowledge of whether Ms. Willis revealed it to anyone?
I have no clue.
Okay. So as far as you know from personal knowledge, no one in the DA's team knew, correct?
That's correct.
Okay. So if it was a legitimate relationship, is there any particular reason why it was kept secret or private?
It wasn't kept secret. It was kept private.
And the purpose for that was?
It's what we chose to do.
I'm asking you why, though, not just because you chose. Why, if you're dating someone, why keep it private?
So, a few reasons. The first one is, and I want to say this respectfully in the right way, there are some people who are in the public eye who just don't like it, don't wish to be there. I have tried to have lunch or dinner with her publicly, and I can't count the number of people that would approach the table or would accost us as we're trying to walk into a restaurant and just have lunch or have a meal. It is not secret, it is private. We don't want the world asking questions or interrupting that time. So we weren't trying to keep anything a secret, Mr. Sadal. There's nothing secret or salacious about having a private life. Nothing.
I'm not suggesting that there was. I'm asking the questions. When you went on the various trips that have been outlined by both Mr. Gillen and by Ms. Merchant, did anyone in the district attorney's office know that the two of you were traveling on personal trips together?
To my knowledge, Mr. Sadal, no.
Okay. And again, that was for privacy, according to your testimony.
Privacy, yes, sir.
Okay. Did you and Miss Willis go to the Hapeville condo prior to your relationship starting at the beginning of 2022?
Prior to having physical contact prior to having intercourse? Did we go to the Hapeville condo?
Again, you keep going to intercourse. I'm trying not to, but fine. The answer to that, or my question would be yes. Did you and Miss Willis go to the Hapeville condo prior to what I want to say November 1st of 2021?
Yes.
Okay, and the purpose for going to the Hapeville condo with Miss Willis prior to 2021 would have been what? Or prior to November 1 of 2021?
Could have been any number of things, because at that time...
That's what I'm asking, so tell me.
Yeah, could have been any number of things, because at that time, she had a friend living in that condo. Miss Yurdy lived in that condo.
Okay. So, it maybe was my question was poorly worded. Let me try again. Your answer is yes, prior to November 1st of 2021, you would have gone to the Hapeville condo and been there with Miss Willis, correct?
Yes.
And you would have been there, as you indicated, for many reasons, right?
Yes.
Can you give me, just list a few of the reasons?
Miss Yurdy resided there, went to visit her, maybe went to talk about a document that I received.
You would go to the condo to talk about a document that you received?
Absolutely.
Okay, go ahead.
Absolutely.
Any other reasons?
None come to mind.
None come to mind?
No, sir.
And would you say that was frequent? When I say frequent, do you think prior to November 1st of 2021, you were at the condo more than 10 times?
No, sir.
So it would be less than 10 times?
Yes, sir.
So if phone records were to reflect that you were making phone calls from the same location as the condo before November 1st of 2021, and it was on multiple occasions, the phone records would be wrong?
If phone records reflected that, yes, sir.
They'd be wrong?
They'd be wrong.
Okay. Where did you live during that time period?
The same place I live now.
Which is not in Hapeville, correct?
It is not in Hapeville.
It is north of Atlanta, the city of Atlanta, correct?
It is.
Okay. And any other reasons why you would be in the Hapeville area on multiple occasions prior to November 1st of 2021?
Let's see. The Porsche Experience is there.
I'm sorry?
The Porsche Experience is there.
Okay, so that would have been one. Any other reason?
Yes, sir. The airport is there.
Airport in Hapeville.
Yes, sir. Delta Airlines is headquartered there. Let's see. Restaurants there.
Okay. If that's your recollection, that's fine. I'm not asking you to try to remember everything, but if that's
okay.
Okay. Did you discuss your affidavit filed in connection with the response with Ms. Willis?
No, sir.
Did you know, personal knowledge, whether Ms. Willis reviewed your affidavit before it was included with the response?
I have no clue.
So, as far as you know, personal knowledge, Ms. Willis did not know what you said in the affidavit.
I didn't give it to her.
That's what I said. You have no personal knowledge.
No personal knowledge.
And as far as you know, no one else has told you that she did or didn't.
I hadn't asked anyone.
We've kind of worked this up a little bit, and the numbers could be off. But according to our numbers, $10,000, give or take, would have been reflected on your credit card statements in connection with things of potential benefit to Ms. Willis, okay? I want you just to assume that. Assuming that there was $10,000 that you had on your credit cards, is it your testimony that Ms. Willis paid you back $10,000 in cash? Now, I'm not acting about...
Can I object? The characterization of $10,000 for Ms. Willis's travel, I don't believe is an accurate reflection of what the numbers, at least the summary that I've been provided by the defense, would reflect. I think that's joint travel. Is that right, Mr. Sato? I'm sorry.
No, it's not joint travel. But all I'm trying to understand, I'll rephrase because I don't want to get bogged down on specific numbers. You would have received thousands of dollars in cash from Ms. Willis, correct?
Yes, sir.
Okay. and the thousands of dollars in cash from Miss Willis, do you know, I'm not asking you whether she took it out of her pocketbook or she took it out of a suitcase. I'm saying, do you know the source of the cash?
Just that, out of her pocketbook. Yes, sir.
You don't know where she obtained the cash?
I didn't ask her.
And the whole time that she was paying you in cash, you never said, hey, why do you have this amount of cash?
Why would, Mr. Sadal, in my practice, people come into my law firm all the time with cash. I never question where they got it.
Yeah, but we're talking not about people that come into your law firm. We're talking about the district attorney of Fulton County, who I'm assuming receives a paycheck. She doesn't get paid in cash.
So just like you assumed, I assumed she got it from her paycheck. I don't know.
Okay. But of course, it's already been, and I'm not going to go back into it. You've not seen any records indicating withdrawals of cash from Miss Willis at all.
Why would I ask her?
I didn't
no,
ask.
sir.
All I said is you haven't, right?
No, sir.
Okay. Now, can you explain why you filed for divorce one day after you were hired by Miss Willis? You filed on November 2nd of 2021. You're hired on November 1st of 2021. Why the day after?
You mean one day before? So
you filed for divorce one day after you were hired, right?
Okay. I'll answer your question.
Okay, please.
So in 2015, when my wife had the affair, we had a conversation that we would divorce right then. Again, the better practice, at least for my children at the time, was to stay in place until the youngest could graduate and matriculate into college. We did that. When she graduated, matriculated into college, at the time my wife had moved back and forth to Houston, to Texas. So she's in Texas. We take our child off to college. We come back to Georgia for a brief period of time. Divorce gets filed. She gets served. There we go. Now, the reason that date was selected.
Yes, sir. That's what I asked.
The specific reason that specific date was selected was because she was only in town for a brief.
Your Honor, this is attorney-client privilege. Why he decided to file his...
And why do you have the right to object on his behalf for attorney-client privilege?
Because...
Well, I'll make a formal objection.
All right, there we go. And...
I believe that he's already attempted to answer this question and there was no privilege raised. So he's given a partial answer and now he's about to finish that. So first of all, I don't think it's covered by attorney-client privilege and I'll deal with that if you want me to. But otherwise, he's already answered part of it. So he doesn't get to say, now I'm going to stop. So.
Well, it was a long preface, but I don't think it ever actually got to what might have been at issue there. So if you can lay the foundation, we'll deal with the objection.
Okay. Take a step back. Okay. You realize that an attorney-client privilege is the privilege of the client, correct?
Yes, sir.
And you, in connection with your representation, at least has been proffered to the court by Mr. Bradley, that it's up to you to decide whether you want to raise the privilege, right?
Yes, sir.
It's not up to Mr. Bradley.
Yes, sir.
So you have the power, in order to get to the truth of the matter, you have the power to waive the attorney-client privilege, do you not?
I believe that's an appropriate question. Certain the privilege is there.
Whether he uses it or not, it doesn't matter why. Mr. Sadal, I think if we're trying to get to the answer to your question, let's figure out whether it covers the question you were trying to get to.
And if I may finish, and your position is you have no intention of waiving your attorney-client privilege, correct?
That's correct.
All right, so now, can you answer the question why you waited until November 2nd, the day after you were hired by Ms. Willis, to file for divorce?
I can.
Okay.
So, again, Joycelyn had relocated to Texas, and she had been in Texas for months. She was only here for a brief period of time to drive my daughter's car back with her. And when she came here to do that, I was able to then get her served.
Okay, so your answer as to why you waited until the day after you were hired by Ms. Willis, which would be November 1st, 2021, to file the complaint for the divorce on November 2nd, 2021, your testimony under oath is because your wife was here. But had not been here in October, had not been here in September, had not been here in August of 2021.
She had been in Texas taking care of her ailing mother and
your testimony,
an aging father. So the first opportunity that I had after speaking with my lawyers to take care of that was the date it was filed and served, because she happened to be here. It had nothing to do with, that was purely coincidental, that contract.
I understand it's purely coincidence, your testimony.
Yes, sir. And understand that this was by agreement between she and I, she being my wife and I, that we would divorce when the children matriculated out, and that there would actually have been an agreement attached to the filing. It became apparent that the agreement wasn't going to happen, and things got a little contentious. So that's when the privilege will kick in, and I was forced to do it when I did it.
Okay. So if I understood correctly, again, you tell me if I'm wrong, is it your testimony that your wife was not in Atlanta, Georgia, or the metro area throughout October of 2021?
No.
That's
In
not your testimony?
In October of 2021, she was back and forth between here and Texas.
Okay, so she was, at least on some occasions, in the Atlanta area.
But that was during the time when we were working through the consent agreement that fell through.
Again, I think we're pretty far afield on relevance. The answer to the question about the timing of the divorce filing.
Understood, Ms. Cross. Ms. Sato, where are we going from here?
We're about to finish this area, since I'm not going to be able to go any further about, if we want to call the X, we'll call the X for that purpose.
Well, we might have to discuss whether that's a collateral issue altogether.
No, I'm just saying if. I didn't say we will, but we'll.
Okay.
All right, so you said that you were aware of the contracts that Mr. Bradley and Mr. Campbell had with the Fulton County District Attorney's Office, correct?
Yes, sir.
And how did you become aware of those?
Just through conversation, they
With
told
who?
me.
Conversation with who?
Mr. Bradley and Mr. Campbell.
So you were discussing matters with Mr. Bradley which were not related to attorney-client privilege, correct?
Related to the contracts, yes.
Okay, but you were having conversations that would not, even though, if I understood correctly, Mr. Bradley was your attorney at the time, correct?
At what time?
At the time that Mr. Bradley received his contract from Fulton County, which would have been beginning of January or in January of 2021, right?
Is that the date of his contract?
Pretty close.
I don't know what the date of his contract was, but if it was after the date of the filing of the divorce, then yeah.
I'm not talking about after the date of the filing of the divorce. It's been represented to the court that you had an attorney-client relationship with Mr. Bradley from 2015 forward.
Yes, sir.
Correct?
Yes, sir. That is correct.
When Mr. Bradley received his contract with Fulton County, that was in 2021, correct?
I don't know.
We can prove that through other evidence. But at the time that Mr. Bradley was doing work for Fulton County, if I understand, you still had an attorney-client privilege, at least you're claiming one, with Mr. Bradley, correct?
Yes.
Okay. So when you talk to Mr. Bradley about matters with his contract in Fulton County, those were not covered by your attorney-client privilege, correct?
They were not.
Okay, and that meant that not all communications with Mr. Bradley were covered by attorney-client privilege, correct?
Well, those certainly weren't.
Well, but my question was, not all communications with Mr. Bradley were covered by, at least as you've been represented to the court, by the attorney-client privilege, correct?
Those communications were not.
So there were communications outside of the attorney-client privilege, correct? With Mr. Bradley.
If you're asking me if I ever communicate with him Outside of the attorney-client privilege, the answer is yes. I've
Okay.
communicated with him outside the attorney-client privilege.
Let's finish this up. And did you call it Roman number 4? Or is it just defense? Okay. In defense exhibit number 4, and Mr. Gillen went over with you your responses to certain interrogatories on May the 30th, 2023. Remember that?
Yes, sir.
Not going back into those. The words in the interrogatories are already in evidence, so we're not going to do that. But the ones that we've gone into, there were 2 of them. And your answer to both of those was none, correct?
Yes, sir.
Okay. Now, on January 25th of 2024,
yes, sir,
you again were in a position that you answered those same interrogatories, the 2 that we're talking about. I can get specific if we need to, but as long as we understand we're talking about the same 2,
yes,
right?
Sir. Yes, sir.
Okay. And they are in defense exhibit number 6, and they are interrogatories number 4 and number 5.
Okay. Go ahead.
No, I want you to be able to see it. So it's a defense exhibit number 6.
I don't.
Does he have 6 up there? I'm told that you have 6.
Okay. Here we are.
Okay. You would agree with me that in defense exhibit number 6, and we're talking about interrogatories of January 25, 2024.
Yes, sir.
That as to interrogatory number 4, that's the same interrogatory, same words that were in the interrogatory that Mr. Gillen went over, which was dated May 30th of 2023, correct?
Yes, sir.
And your original response in defense exhibit number 6 was none, correct?
Yes, sir.
Your updated response was the plaintiff declines to respond to this interrogatory and asserts his privilege pursuant to OCGA section 24-5-505, correct?
Yes, sir.
You know that 24-5-505 breaks down into two privileges, right?
Which is why I was specific. I said I asserted the privacy privilege.
Well, that's what I'm asking you. In your updated response, there's no reference to privacy, correct?
Yes, there is in the code section 24-5-505.
Okay, but it also
reference to privacy.
Right. Just go with me, okay? That code section says, does it not? No party or witness shall be required to testify as to any matter which may incriminate or tend to incriminate such party or witness, or which shall tend to bring infamy, disgrace, or public contempt upon such party or witness. You'd agree with that, right?
I'm not reading it.
I'm sorry?
I'm not reading it. I don't have it in front of me.
If I may.
Mr. Sano, we can, I can take judicial notice that is what the rule says if you want to ask him any follow-up questions.
Okay, thank you. You are not claiming that your answer to number 4, interrogatory number 4, on January 25th, 2024, incriminates you, that is, as in Fifth Amendment privilege, right?
That's correct.
You're claiming the second part, that it would bring infamy, disgrace, or public contempt, correct?
I'm going to object to that. I don't think that's the full thing, but and also the witness doesn't have it in front of him, so I don't know how he could respond to that. I think he's said several times privacy is largely invoked that statutory.
Overruled.
I'm claiming privacy.
The privilege that you make reference to is to infamy, disgrace, or public contempt upon the witness, right? Or party. That's the section that you were relying on, correct?
If that's what it says, yes, sir.
Okay, look. I could show you, but I think the court has already indicated he can take judicial notice of the statute. So assume that what I'm telling you is accurate, okay?
Yes, sir.
Okay. How would an answer of none bring infamy, disgrace, or public contempt upon you?
So, as I explained in direct of Mr. Roman's counsel, the minute she elected to intervene into my divorce proceeding, I then started to understand the bigger picture, which was that all the attorneys in the election interference case were colluding with Joycelyn's divorce lawyer, and because of that, I said, privacy. I don't want my divorce proceeding to bleed into this criminal proceeding. I just didn't want that.
So you raised a privilege, if I understand, that indicated that your answer would bring infamy, disgrace, or public contempt upon you, right?
Your Honor, I'm going to object to the relevance of this. It's been asked and answered several times.
Mr. Seda, where are we heading with this?
I think I can finish that up by saying you didn't say none again. You asserted a privilege, correct?
That's correct.
Okay. And you did the same thing, did you not, with number 5?
That's correct.
That is, you didn't say none again, right?
Correct.
Okay. Is the answer to the interrogatory number 4, as you have it in front of you, is the answer none? Is that the truth?
The answer is, to that interrogatory, is as I placed it at the time I responded, sir.
I'm asking you now, is the answer to that interrogatory none?
The answer is still privilege.
All right. So he's apparently electing to apply the same privilege, Mr. Seda, to that exact same question.
And I have a case which indicates that we can get beyond that if the court deems that appropriate.
And to what end? To what end? Where?
That the privilege actually does not apply, and he must answer the question.
And where does that get us? Even if he answers the question, hasn't he already kind of said everything he has to say about the nature of the relationship, how long it lasted, when it ended?
No, I think it would prove. I think if he is forced or compelled to answer the question, he will either answer it falsely by saying none, or he answer it truthfully by saying yes, and then telling us what it is. That's what I believe. That's why I'm asking.
But the interrogatory you're referring to, though, the question contained there.
Two interrogatories, yes, sir.
It's the entertaining one. It's whether there were other relationships, right?
With a specific language that's in the interrogatories.
Sure. Haven't you already covered that in all the other questions that we've had so far?
We have, but again, the court could, if I could require or compel an answer from him as to whether his answer would still be none, then we would know whether or not he was telling the truth. Now, if the answer is no, then obviously there was a time in the past where he was not. It simply requires him to now answer under oath what he refused to answer and claimed, but I might suggest it's a bogus privilege, and that you can pierce that privilege because it's a material fact in connection with this case. Again, it's a call that Your Honor makes. I have case law that says you can do that, but it's your discretion.
Ms. Cross?
Your Honor, Mr. Bates has been on the stand now for several hours. He's been asked and answered very personal questions that I believe cover the issues. Mr. Seda was making an argument, and this is probably an argument to make for the later to the court and not a question to propound to it.
So as I see it, the only relevance these interrogatories have to this case really whatsoever would be as either prior inconsistent or consistent statements. And to that end, I think the question has been put to him again and again and again. He's answered how he believes he felt his answer should be and why he answered a certain way. And as it goes to credibility, I think at this point we're arguing weight, and I don't really see the value in pushing this issue further. So,
all right. Well, just for the record, the case that I was going to refer to is State versus Wakefield at 324 Georgia Appeal 587, and specifically, let's see, it would be 590, in which they talk about this specific privilege. This is a 2013 case. And then they footnote to footnote 3. And footnote 3 says, there are times when the materiality of the evidence outweighs the testimonial privilege. And it goes and explains what that is. That's what I'm bringing up.
And I see what you're saying, that we could say that you need to answer the question regardless of the privilege you asserted. At this point, though, I think we've covered that ground and we're ready to move on.
Okay. Based on that, I have nothing else. Thank you.
Okay. Mr. McCulloch? Anything on behalf of Mr. Floyd? Moving through defense counsel.
Oh, I'm sorry.
No, I'm looking behind you. Mr. McCullough.
Okay.
On behalf of Mr. Floyd, he's elbowing you, sir. Okay. Mr. Cromwell.
Nothing, Your Honor.
All right. Ms. Cross.
Thank you. Mr. Wade, have you still got exhibit number 14 in front of you? The one with all of the invoices, I believe.
I believe I have them all.
All right. So you were asked, Mr. Wade, about a couple of the invoice items. And your testimony, I think, was that the percentage of income post special counsel appointment in November 2021, the percentage of your income roughly after that time was about 50-50 Fulton versus other income from your law practice, correct?
Roughly, yes, ma'am.
Okay. Sometimes more, sometimes less?
Yes, ma'am.
All right. How about your time? I'm interested in the percentage of your time from November 2021 to, let's say, the close of the special purpose grand jury when it was dissolved in January 2023. Can you estimate for us the percentage of your time that was spent on Fulton County work versus other work?
Oh, gosh. 99% of the time here in this building working on this case.
All right. It was, as I understood your testimony, it was an intense period in terms of hours while that special purpose grand jury was meeting, correct?
Yes, ma'am.
And who was head or manager of the election integrity case during that time for the district attorney's office?
I was.
You were coordinating the efforts?
Yes, ma'am.
And those efforts included not just the proceedings that were happening in this building, correct?
That's correct.
We don't need to go all through it, but is your representation that 99.9% of the time, let's restrict it to 2022, 99% of your professional working time was devoted to this case?
Yes, ma'am.
And the remainder, whatever it was to some of your other cases that were ongoing?
Yes, ma'am.
All right. 2022, I want to focus on that a little bit because if we are looking at, I believe, the financial affidavits, do you have those in front of you as well?
I do.
The financial affidavit that was filed in your divorce case in January 2022, you estimated your monthly income at that time was $14,000 a month, right?
In 22?
January 22.
Yes, ma'am.
January 23, what'd that number come to?
9,000.
What about 2024?
I don't know.
Is that there in front of you? Is that one? That's not one of the ones that's there in front of you?
No, ma'am.
All right. So as reflected in those financial affidavits, your income decreased as a result of your work in this case, correct?
Significantly.
The structure of your firm, we talked a lot about that, and I don't want to go through it anymore, but than we need to. But 2022, the structure of your firm changed. Is that correct?
That's correct.
Right. In the early part of 2022, there were three of you. You and Mr. Campbell and Mr. Bradley, you split expenses. Is that right?
That's correct.
And you profit shared among yourselves, correct?
Correct.
Right. After Mr. Bradley left the firm, then there were just two of you, correct?
That is the cause of the significant change. Yes, ma'am.
So now you have two people bringing in income, correct?
Correct.
And one of those people, you, is spending almost all of your time devoted to this election integrity case, correct?
Yes, ma'am.
Right. And your income from this election integrity case is less than what it was the year before.
Yes, ma'am.
We talked about the monthly caps, or we didn't talk about it. There was talk about the monthly cap that was included in your contracts, indicating there was a certain threshold that you could reach, number of hours a month, and over that amount you were not going to be compensated, correct?
That's correct.
All right. And you kind of smiled when you said that. That's a little bittersweet there, isn't it?
That's bitter.
All right. Exhibit 14, is that still there in front of you?
It is.
I want you to take a look, please. That's a collection of exhibits that includes all of your invoices, as was represented. I want you to take a look at invoice number 9.
Yes, ma'am.
Is that there in front of you?
I have it.
Invoice number 9, Mr. Wade, indicates that you performed hours of work that you were not compensated for because your cap had been reached.
Yes, ma'am.
I want you to take, and what did you do in those circumstances? When the hours that you worked per month were more than the cap that was in your contract that you were permitted to be paid for?
I was forced to lose that time. I didn't get paid for it.
Okay. And that's what exhibit number 9 shows?
Yes, ma'am.
All right. And in exhibit number 9, you've got a task, hours that were completed, and you just didn't bill for it. You noted the time and then a 0 beside it because you didn't bill the county for that time.
Yes, ma'am.
All right. What about exhibit number, invoice number 13? Can you flip to that for me?
I have it.
Is that a similar situation?
Yes, ma'am, it is.
And what is it on invoice number 13?
This invoice makes me cry. There's so many hours here that I worked that I couldn't get paid for. So.
And you work those hours anyway, Mr. Wade?
Oh, absolutely. This is not the type of job that you could walk away from just because you're not getting paid for it. I think there's some professional rules of responsibility to an attorney who's engaged in a case. You have to see it through. So it's not like I could just throw my hands up and say, well, I reached my monthly cap, I'm done, I can walk away. I can't do that. This is ongoing, it's constant, and I have to do the work.
Can you look at invoice number 23 for me there in exhibit number 14?
Yes, ma'am.
Does that reflect a similar situation, the hours worked that you were not compensated for?
Yes, ma'am.
Invoice number 24 and 27, can you take a look at those and let us know if that reflects the same situation?
Are you trying to depress me?
No,
Look at the money I'm losing.
Okay.
It's the same, yes.
Okay. And there's no workaround to that? You didn't attempt to work around that contractual cap on your hours?
Oh, no, ma'am.
All right. You were asked a lot of questions, Mr. Wade, about the affidavit that was submitted, correct? Do you recall those questions?
I'm sorry, I'm stuck on this invoice. You know, if I was going to get a benefit, I'd like that benefit. That's the one I want. That didn't happen.
That didn't happen.
Okay.
All right. And there was no renegotiating your contract to reflect that those hours should be paid or anything?
No, ma'am.
Okay. All right. Do you have your affidavit there in front of you?
I do.
The affidavit, of course, was attached to and provided in support of the state's response to Mr. Roming's motion, correct?
Yes, ma'am.
All right. And you prepared that affidavit?
I did.
You signed that affidavit?
I did.
All of the allegations and the representations in that affidavit are true. Is that right, Mr. Wade?
Every one of them.
Every one of them. You were asked a lot of questions about our line number 34. Can you turn to that for me, please? It's on page 4 of that affidavit.
Yes, ma'am.
Can you read it out loud for me, please?
The district attorney and I are both financially independent professionals. Expenses for personal travel were roughly divided equally between us. At times, I have made and purchased travel for District Attorney Willis and myself from my personal funds. At other times, District Attorney Willis has made and purchased travel for she and I from her personal funds. Examples of District Attorney Willis's purchasing plane tickets for she and I with her personal funds for our personal travel are attached.
Funds, Mr. Wade. As you understand the term funds, does that include cash?
Yes.
Does that include credit?
Yes.
Does that include reimbursements?
Yes.
You didn't represent in your affidavit, Mr. Wade, that you were including all of the receipts from funds or travel expenses that were paid on your behalf by District Attorney Willis, correct?
That's correct.
You had, I think your conversation with Ms. Merchant was you produced the receipt that you had.
Yes, ma'am.
Are you aware of any other receipts? Well, let me ask it this way. May I put you on the third stick? That's all right. I'm going to write it on there now. I'm going to mark. I'm going to mark this as State's Exhibit number 1. You testified, Mr. Wade, that District Attorney Willis purchased and funded the entire trip to Belize. That was her treat to you for a birthday?
Yes, ma'am.
And you testified that she purchased the plane tickets for you, correct?
Yes, ma'am.
And while you may not have had the receipts on hand when you filled out the affidavit because they weren't in your possession, are you aware now that there are receipts and that it reflects that the district attorney...
If this is going to go into evidence, we'd like to look at it first.
I've got a copy. Do you remember, Mr. Wade, approximately how much, and that's again State's Exhibit number 1, my first one is now. Do you remember how much the flight was for you, your flight to Belize? And if you don't, I'm not tendering it for you. I'm just asking you to take a look at that and see if that refreshes your recollection as to the amount that that plane ticket cost that was extended by District Attorney. You may keep it. You keep it. Does that refresh your recollection, Mr. Wade?
It does, thank you.
Approximately how much was the amount of the ticket that District Attorney Willis purchased for your travel to Belize?
$887.35.
And I'm not tendering it, Your Honor, but I will leave it with the court reporter for reference. All right, Mr. Wade, your testimony here in court today and consistent with your affidavit was that the personal relationship, I think we've called it dating today as well, the personal or dating relationship between you and the district attorney began sometime in early 2022, March, I think was your testimony, is that right?
Yes, ma'am.
Right. And that March date isn't included in the affidavit. The affidavit is less specific, but that was your testimony today?
Yes, ma'am.
And that there was no personal or dating relationship prior to that time, right?
None.
Right. Mr. Wade, I'm sorry. I'm going to direct your attention to 2020. In 2020, were you dating the district attorney?
No.
2020, that was during the COVID pandemic, correct?
It was.
Was there a situation for you, Mr. Wade, that made you particularly vulnerable during the COVID period?
Yes, ma'am. And in 2020, and a portion of 21, I was battling cancer, and that prevented me from pretty much leaving environments that aren't sterile, and I had health on my mind.
You were particularly cautious during that time?
Yes, ma'am.
Were you dating anyone in 2020?
No, ma'am.
All right. Thank you, Mr. Wade. That's all I have.
Ms. Merchant, recross on those points only.
Yes, thank you. All right, Mr. Wade. The state asked you about how much money you're making now versus before, and you said you're making significantly less since you've started working for Fulton County, correct?
Well, I did say that, but what we're talking about is because now at this point the splitting of the financial obligations in the firm are now there are two people carrying the weight of three, so that would scale back on the amount of income, right? Amount of profit.
Well, you're splitting the profits 50-50 though, instead of 1/3, correct?
The profits, yes.
Okay. So, but you did testify that you're making significantly less now. We heard about it for a few minutes. Significantly less now that you work for Fulton County, right?
Yes.
Okay. Would you agree with me that $236,000 is more than $184,000?
Absolutely.
Would you agree with me that $262,000 is more than $236,000?
Absolutely.
All of these years, despite you saying that you were a three-way partner with Wade and Campbell and Bradley, and now a two-way partner with Campbell, all of your corporate tax returns are filed in the law firm of Nathan Wade, though, correct?
My returns, yes, ma'am.
Yes, for your law firm.
Well, for my law firm, because I also have personal returns.
Right, and I'm not talking about your personal returns. I'm talking about your business returns.
Yeah, but the question contemplates that my bring home money is more or less. So I want to be clear that is reflected in my personal returns.
I didn't ask you anything about bring home money, though. I'm not sure what you're talking about.
What I'm talking about is your question was the portion of my testimony dealing with earning significantly less money.
No. My question is I'll just break it down. During 2019, you filed your business returns. I'm not talking about your personal. Your business returns for the law firm of Nathan Wade only, correct?
I filed personal and business. Yes, ma'am.
And even though you said you were partners with Bradley and Campbell later on, you filed your business returns not with them, but as a solo practitioner, correct?
I see where you're going. There's a different return for that Wade, Bradley, Campbell entity.
And I'm not asking about that. What I'm asking about is during the years 2019, 2020, 2021, and 2022, you filed a business return for the law firm of Nathan Wade.
Yes, ma'am.
And in 2019, you said that the law firm of Nathan Wade made $184,000, correct?
No, I don't know.
Does that sound familiar? Does that sound about like what you made in 2019 and reported on your taxes as a business law firm?
If that's what's on the return, yes, ma'am, you're right.
Okay, and I'm happy I can bring those up. I've got one copy. I'm not planning on admitting them because they're tax returns, but okay. All right, may I approach, Judge?
Yeah.
Thank you. So in 2019, gross profit for the law firm of Nathan Wade is $184,000, correct?
Let's see.
The second line, number 2, gross profit.
Yes, ma'am. 184,824. Yes, ma'am.
Okay. And then in 2020, you also filed Nathan Wade, attorney at law, and your gross profit was $230,000, correct?
Yes, ma'am.
And in 2021, you also filed as a solo Nathan Wade PC attorney at law, and your gross profit was $236,000, correct?
Yes, ma'am.
And then in 2022, you filed as a solo practitioner Nathan Wade, and your gross income was $262,000, correct?
Yes, ma'am.
Okay. I'm not going to end the business. You've got your social. But nowhere in these documents do you document that you received cash payments from Ms. Willis, correct?
I don't. I hadn't looked through them. I would be surprised if there were something in there that said that.
Do you want to look through them?
Listen to the answer. I'd be shocked if there was something in there that said that I received some cash from Ms. Willis.
Okay. But there is itemized expenditures for travel in here. You did itemize that.
I didn't itemize anything.
Your accountant itemized it.
I hope so.
But you're responsible for your taxes, even if your accountant files them, right?
I agree.
And so you itemized your expenses for travel on all these documents, but you did not itemize. You didn't put anything in there about you being reimbursed for half of that travel.
Well, those are business returns.
Yes, you used your business card to pay for the travel, right?
Yeah, but I wouldn't put a personal expense on a business return.
But you used a business card to pay for these personal travel.
I use a business card to pay for everything. And what I do is turn over the statement to the accountant, and the accountant then says, okay, this expense, that's personal. We'll put that over here. This expense, that's business. We'll put that over here. And they reconcile it. So you wouldn't find a reimbursement from Ms. Willis on a business return.
Okay, so they're not anywhere there.
Nor would you find, well, go ahead.
No, I'm just asking. So there's nowhere for any of that cash to be reconciled there, right?
On the business returns, no, ma'am.
Okay. We talked a lot about the financial affidavits. I know the state asked you a couple questions about them. You filed one in 2022. In that one, you stated that you only had $5,000 in cash, correct?
I believe you. Yes, ma'am.
That was sworn under oath?
At the time of the filing, yes, ma'am.
Okay. And then in January of 2024, you filed another one that also swore that you only had $5,000 in cash, correct?
At the time of the filing, yes, ma'am.
Okay. So in 2022 and 2024, you only had $5,000 in cash?
At that time, yes, ma'am.
At that time?
And then you also, all of those interrogatories, I'm not going to go through them in painstaking detail, but every single interrogatory you filed, there are 4 of them, all verified ones. Every single one, you said you didn't have any cash stored in a safe, a safety deposit box, or any other location. Plaintiff rarely carries cash. If plaintiff does carry cash, it's a nominal amount, correct?
That's correct.
Okay. So we've got what? 2021, you said you don't have cash. 2023, you said you don't have cash. Again in 2023, you said you don't have cash. And then in 2024, you don't have cash, right?
So you're assuming that I received the cash and I stored it. I received the cash and I saved it.
Well, you didn't put it in the bank, right?
What's wrong with receiving the cash, Ms. Merchant, and spending it?
Nothing's wrong with it, but you didn't put it in the bank.
That would contemplate why the response is what it is on the interrogatories.
So you spent the cash. That's because before, when it was asked, you said you didn't want to disclose where the cash was.
No.
Privacy reasons.
No. Well, I said that if I were to store cash in my home, then why would I share that with the world, is what I said. I didn't say that I had some cash stored up in some place, because that's not the truth.
And you've talked a lot about this, I split with a third, I split with half. From the check you received from Fulton County, July 15th, 2022. So all the way back for July 2022, not a single check that you've received from Fulton County has gone into a joint banking account. Every single check has gone into your own personal banking account, correct?
All of them, with the exception of the checks that were going into the WBC firm, went into my business bank account, which is solely in my name.
Right, your WBC account that you're talking about, that account was closed, though, in June of 2022.
Correct.
Okay. So everything after June of 2022 was put in a Nathan Wade bank account, not a corporate bank account with partners.
I think the question right before that only needed a yes or no.
So no, ma'am. The checks were deposited into firm accounts, law firm accounts.
Law firm of Nathan Wade PC.
Yes, ma'am.
As a solo practitioner.
Yes, ma'am.
Okay, so they were not deposited into accounts with Campbell or Bradley.
No, ma'am, they were not.
Thank
However, there were checks written to Campbell and Bradley that will reflect the third.
And we've tried to get those bank records, but you've objected to those, correct?
You've tried to get what bank records?
We subpoenaed bank records, and you've objected to all of those, right?
Your Honor, I'm going to object to their relevance.
It's relevant if he's saying he has all these records, but yet we've tried to get them, and he's trying to keep them from us, but he doesn't bring all of the records. And you can make an inference if there's law that says you can make an inference if some documents are within the party's control and they won't provide them, that there's an inference that they're not positive.
Ms. Gross.
Your Honor, there was no obligation for Mr. Wade to produce evidence that Ms. Merchant couldn't find an admissible way to produce. I believe it's irrelevant. We've covered the ground, and I object to any further questioning.
All right, I'll sustain that. Ms. Merchant, let's find some new ground here.
Okay, thank you. Are you willing to waive your privilege with Mr. Bradley so that he can testify?
I am not willing to waive attorney-client privilege.
Okay, thank you.
Only on the questions, the health questions that were asked on campus. And I can ask it from here because it's very short. I don't want to get into the type of cancer. I don't want to get into the medical condition itself. Did I understand you to say that you had cancer in the year of 2020?
Yes, sir.
And you explained that because of that, in 2020, you kept yourself in a sterile environment?
I tried, yes, sir.
Now, what about 2021?
2021, just focusing on my health, trying to get back to myself.
You remember I asked you some questions about Hateville?
Yes, sir.
And the condo?
Yes, sir.
And you indicated that prior to November 1st of 2021, you had spent time at the condo, the Hateville condo?
Yes, sir.
With Miss Willis, right?
Yes, sir.
And with someone else? You said Miss Yearty?
Miss Yearty, yes, sir.
Okay, so you were not concerned, that was not a sterile environment, was it?
Are you inferring that Miss Yearty and D.A. Willis is not sterile? Of course it's a sterile environment. It's a condo.
But don't you remember then I followed up and said, where else might you have been to show your cell phone records from Hateville? And you said, the airport, right? Not a sterile environment, though, the airport. You agree?
It is not.
Okay, what about restaurants? Not a sterile environment, right?
They are not.
And the Porsche, you said something about a Porsche what?
Porsche experience.
That doesn't sound very sterile to me. Is that a sterile environment?
You're inside of your vehicle.
Yeah, but don't you mingle with others?
You can.
Yeah, and you were doing all that in 2021 before November 1st. That's what you testified to, correct?
Yes, sir.
So there's no reason why you couldn't be dating in 2021, is there?
You mean 2020, Mr. Sadow?
No, I said 2021.
All right.
Correct?
Dating? No.
No reason.
No reason.
Got it. Thanks.
All right, Mr. Gillen? Okay. Mr. Stockton, excuse me.
Just real briefly, you said you started dating in early 2022, and you also used the term personal relationship. And there was no dating and no personal relationship prior to early 22. Is that correct?
Help me understand. I want to make sure I answer you. So let's be clear. 2022 was the start of any intimate sexual relationship with the district attorney.
Okay, and that's what I was wanting to
Okay.
be clear. In your affidavit, you used the term personal relationship.
Got it.
Today, you've used the term dating. And your testimony today is that that includes the term basically physical or sexual or intimate relationship. Is that correct?
Yes, sir.
And there was nothing, according to your testimony, there was none of that prior to early 2020.
That is correct.
That's all I've got, Judge.
All right, not seeing anyone else. Ms. Cross, any redirect? All right, Ms. Merchant, can this witness be excused?
Judge, we'd ask to keep him under subpoena. We might need him to come back after the
All right. All right, you may step down, Mr. Wade, and please don't discuss your testimony with any other witnesses.
She mentioned subpoena, Judge. Let me just say this. That was an inference made that I was somehow evading service of a subpoena.
We can take that up. I don't think we need to have that on the record in this hearing. Understood, Bill.
Thank you.
All right, Ms. Merchant, any other witnesses?
Yes, we would call Fani Willis.
All right, Ms. Cross.
Your Honor, I am going to object and remove to the motion to quash the district attorneys. There's been now lots of testimony from Mr. Wade. I don't believe that there can be a showing for the need for the district attorney to testify as well. For all of the reasons that were cited in the state's motion to quash initially, it's a tremendously high burden to call opposing counsel. I don't believe it's been met, particularly given the cumulative nature that would be the subject of personal details that Mr. Wade's not testified to.
All right, Ms. Merchant, what do you think you can establish and have through the testimony of Ms. Willis? And let me stop there.
Conflict in the evidence, Judge. Now that Mr. Wade has testified, there's a conflict in multiple different issues. I'll just go through all the different issues. The first one is the reimbursement issue. The cash, that opens the door in and of itself to Ms. Willis testifying.
Well, what's the conflict there?
That he testified that he didn't have receipts, but we don't know if Ms. Willis has receipts. So that's one issue.
So we don't know. So there's no conflict. We just don't know.
We don't
right?
know. Right?
Okay. So it's a question, not a conflict. But what else do we
That is a question. So, and there's a lot of different issues with different reasons. The first one would be the receipts. Whether or not these cash payments, if there's any payment receipts. The Belize trip, whether or not she paid for the entire thing in cash. Mr. Wade doesn't have knowledge of that. Couldn't remember a lot of things he couldn't remember. So now it goes to Ms. Willis, unfortunately. That he testified that she insists on paying her own way, gave him some cash, that's the quote, some cash. Miami trip, she booked it but thought it would balance out. A couple other trips that we didn't get any information about, Tennessee, Alabama, Georgia, all of those could be financial benefits. We don't know. He didn't know. He was very vague about that. Yuri, her best friend, testified that it happened in 2019. And now Mr. Wade has testified that the relationship began to become romantic in 2022, I think is what his testimony says. So that is a conflict in and of itself. Right there, that's a big conflict. We've also got more receipts, but the biggest thing about the conflict is when the relationship started. He said he talked with Willis in the conference room after we filed our motion. He specifically didn't use cash, the term cash in the affidavit, but he told anybody who would ask about the cash. And he specifically discussed this and the response. We have a right to go over these.
All right, so you've highlighted the areas you'd like to go into. I think the central question may be, what is it, other than, I'm just really curious what she has to say, you have to put on the record? And so that's what I'd like to go through. Ms. Cross?
I think you've identified, Ms. Merchant hasn't itemized inconsistencies for you. She's identified areas of inquiry. The testimony in the record from Mr. Wade is it's not inconsistent, it's unrebutted. Excuse me. And so that I don't believe, given the testimony of Mr. Wade and the extent of the questioning of him, that there is any reason at this point to go into the district attorney herself. Again, I know the court's read all the pleadings. It really is such a compelling need, is the language of the case law, a compelling need to call opposing counsel. Given the record that's now before the court, I don't believe it's been made.
Your Honor, Mr. Gillen, very briefly, Ms. Willis needs to testify. Her best friend or good friend has directly contradicted the declaration that was made by Mr. Wade attached to the government's response. And it wasn't just the declaration of Mr. Wade, it was filed by the district attorney by and through her assistants here. She owns that. And so that affidavit is owned by her, and there are deep concerns that that affidavit is false, and that Ms. Willis knew it was false, and that she needs to come in here if she wants to tell us about the cash. First time we've heard about the cash, oh yeah, we got cash. Don't have any deposit slips, don't have any record of it. Maybe Ms. Willis can say, here, all my records where I paid $10,000 in cash back to Mr. Wade. We need to know that. Also, Ms. Willis's financial disclosure. Let's not forget that. We're talking about two people who went to extraordinary lengths to hide their relationship, to hide the nature of their relationship. Extraordinary. The district attorney needs to take the stand, and she needs to tell this court and this courtroom why she filed financial disclosures in 2022 identifying prohibited sources, which Mr. Wade clearly is a prohibited source. Did you get gifts and benefits? Now we've seen all this. We've seen the trips. We've seen all of the things that total up to around $10,000 in cash. Yet on the financial declaration for 2021, which was filed in April of 2022, and the financial declaration for 2022, which was filed in April of 2023, there is no listing of any gifts whatsoever over $100 from a prohibited source. It cries out for her testimony. She needs to be able to get up here and say, why didn't you tell on the disclosure form, so that people will know the nature of the relationship between prohibited sources and the public official, in this case the district attorney, who happens to then make a decision to hire someone that ends up being paid hundreds of thousands of dollars, or his firm and him, and none of that is revealed. And the answer is, oh, it's unrebutted. He's explained it's all in cash. Let her get up, and let's, and obviously, we are advocates in our position, but that explanation of cash does not pass the smell test or the straight face test. She needs to go on the record. She filed this motion with his declaration. We've seen what happened here. Now, just 2 or 3 more sentences. We need to have the full picture, as we've gotten through Mr. Wade, of his false interrogatory. Serious business for a lawyer or anybody. And then suddenly he's changing it. She files her financial declarations, same problems. We need her in here to go over all of this and to explain exactly what happened. So we would ask the court that the court allow Ms. Willis to be called and interrogated on these matters.
And I would too, Your Honor.
Just a moment, Ms. Willis. So, Ms. Cross, I don't know if you want to speak with Ms. Willis now. It's sounding like maybe they're withdrawing
I believe I'm
the objection to the motion?
I believe the motion to,
Or does Ms. Willis want to take the lead here?
we'll withdraw the motion to quash Ms. Willis.
Based on the, I'm ready to go.
Okay, so the position of the district attorney at this point is that she's no longer contesting the subpoena. Ms. Merchant has called her as the next witness.
I would ask, I need 3 documents in front of me, and they're the 3 filings of Ms. Merchant.
3 filings.
Does anyone have the 3 filings of Ms. Merchant? Does the court have the 3 filings of Ms. Merchant?
When you say the filings, you mean like the pleadings?
The pleadings, yes, Your Honor.
Okay. I think we could locate those for you. I mean, the supplemental.
I want the one filed on January the 8th, the one filed immediately after we filed ours, and the final one.
If you want to take a break to get them, I can make a copy. I think we have one.
You know, the only copy I have is going to have my notes on it. So if we don't have a clean copy,
Have a 5-minute break during,
Let's
I'll get
take
the documents.
all right.
I'll sit here and wait for him.
Did we elect someone who's actually making the copy? You got it? Okay. Ms. Cross is doing it.
There. I can.
Yeah, so.
Give a tissue.
Thank you, Your Honor. I appreciate the courtesy. They should be here in just a second.
All right, Ms. Cross, you can bring everyone in. Thank you.
Do you swear me, Your Honor?
You want
Do
to
you,
take that?
whomever would like to.
We got Deputy Scott usually. So let's go, wait a minute, let everyone get situated and then we'll go back on the record.
Sir, do you have like tissue in here?
All right, we are back on the record. Deputy Scott, if you could swear in our next witness.
I would, and I do apologize. Anna, do me a favor. Put them on my knees and leave the glasses. After you swear me, tell me what I need. If it's swear, you can go ahead and swear me so I don't hold it before. Yes, sir. District Attorney Fani, F-A-N-I. Last name is Willis.
Ms. Willis, how did you know to come into the courtroom right then?
There were people I was pacing in my office.
Okay.
And I heard someone yell, his testimony is done. It only made sense to me that I would be your next witness. And I've been very anxious to have this conversation with you today. So I ran to the courtroom.
So as soon as you heard that Mr. Wade was done testifying, that's when you just assumed you would be the next witness?
It only makes sense.
Did you listen to any of the testimony?
I've been in my office pacing, ma'am.
Did you listen to any of the arguments?
I did hear the arguments this morning. It's ridiculous to me that you lied on Monday, and yet here we still are. And I did listen to that argument.
All right, so that was it, just the argument, no testimony.
Right, I listened to the argument this morning where Adam Abadi, I thought, did an excellent job pointing out how dishonest you were with the court on Monday. And I'm actually surprised that the hearing continued, but since it did, here I am.
Great. So let's just talk about what you did in preparation for today. Did you meet with Mr. Wade at all? Once the motion was filed, did you meet with Mr. Wade and talk to him about the motion that I filed to disqualify you?
On this first January motion?
Yes.
I don't know if you could say talked about. I probably had some choice words about some of the things that you said that were dishonest within this motion. So I don't know that it was a conversation. As you know, Mr. Wade is a Southern gentleman. Me, not so much.
Okay, but my question was, did you have a conversation with
I
him?
didn't have a substantive conversation.
You did not?
I read this motion, skimmed it more so, and I've probably said some choice things to him about some of the lies they were told.
Okay.
And been printed in the media because, you know, we used to be in a day and time where you had 60 Minutes and people did stories and they verified information, and you had this great reporting. But it seems today that a lawyer writes a lie and then it's printed for all of the world to see.
Well, I just want to make sure that you answer the question I asked, though. So my question was...
I'm going to object. Then ask an answer.
Overruled, Mr. Abadi.
I told you what happened. I read the motion. I am sure I told him what my opinion of it is.
Okay.
And past that, we had no substantive conversation.
You did not? Okay.
Is there something you didn't understand?
No, I just wanted to make sure that
Okay.
you did not have a meeting with him in the conference room to discuss the motion.
Next question,
No.
Ms. Merchant.
So in the conference room of my office within this week, you produced some financial document. That financial document was given to me, something, and I'm not even sure who was giving it to him by me or Mr. Abadi gave it to me. And I think he showed me a document in our conference room. But as far as a substantive conversation, I don't believe I've had any conversation with him that is substantive related to this.
Okay.
I have had conversations with him since you filed the motion, but they wouldn't be substantive to this. He sent me very nice sermons that have been done. And so we've had conversations about, did you listen to that sermon? You know, things of that nature. And I would say they were in relationship to this because I think he did it to be kind.
Okay. Let's start back in 2019.
Yeah.
So you and Mr. Wade met in October 2019 at a conference?
That is correct. And I think in one of your motions you tried to implicate I slept with him at that conference, which I find to be extremely offensive. I stayed at that conference. Mr. Wade was my teacher. I did not meet him when he taught the class. I was standing outside talking to Lisa Reeves, who is a judge. Me and her were just having a conversation. Mr. Wade walks up. I think they hug each other. They have some brief conversation. She introduces us.
Your Honor, I'm going to object. We kind of thought that when we asked the question, you didn't answer the question, not a speech, so I object to the speech.
I agree,
I'm
Judge.
able to explain my answers.
I believe she's able to explain her answer.
And that's
Ms. Merchant, that's okay. I can handle it. Ms. Willis, I'll ask you just listen to the answer, or excuse me, the question, and keep the answers confined to the question as best you can. I think you'll have more than enough ample opportunity on when the state was
Well,
able
it's
to ask
highly
follow-ups.
offensive when someone lies on you, and it's highly offensive when they try
Judge.
to implicate that you slept with somebody the first day you met with them, and I take exception to it.
All right. Well, Ms. Willis, you'll have the opportunity to explain all of that when it's the state's turn to ask more open-ended questions.
Yeah.
Ms. Merchant.
Thank you, Judge. So again, my question was, you all met at that conference, though, right?
We did. The meeting,
Okay.
he, as I stated, he taught the class. I did not actually meet him when he taught the class. I walked out of the class, and I'm not sure if it was that exact class or we had went to lunch, but we were standing in the vestibule, like outside of the class. Me and Judge Reeves were having a conversation. She had worked at a law firm I worked at back in 1996.
We're getting way afar. I mean, I don't mind her explaining her answers, but I literally just asked if they met at that
She's
conference.
explaining how she met Mr. Wade, which was exactly the question asked by Ms. Merchant.
It was-
These answers are more than appropriate.
Ms. Merchant, if you want more concise answers, perhaps you could lead the witness.
I will. Thank you, Judge. Isn't it true that you met Mr. Wade October 2019 at a judge's
We
conference?
haven't gotten to the point where Ms. Willis should be treated also in this situation.
I think we
Well,
have.
I'm very
Mr.
much
Abadi.
want to be here, so I'm not a hostile witness. I very much want to be
Not
here.
so much that you're hostile, Ms. Willis. It'd be an adverse witness. Your interests are opposed to Ms. Merchant's.
Thank you.
Merchant's interests are contrary to democracy, Your Honor, not to mine.
All right, let's
Judge,
proceed.
I would just ask that
We can keep things moving. Ms.
Thank
Merchant,
you.
next question,
Thank you.
please.
Okay, so we've confirmed when you met. After that, isn't it true?
No, I need to explain this, and I think I get to explain my answers. When I met him, Judge Reeves introduced us. He handed me his business card. I'm unsure if I handed him my business card, but we exchanged information. He said, if you ever need any help, give me a call. And he walked to the parking lot.
So after that, you started dating shortly thereafter, correct?
A lie. That's one of your lies.
Okay. Do you know Robin Yurdy?
I know her as Robin Bryant. I knew her. So Robin did not go to my college. She went to the college of, I went to Howard University. She went to Morgan State. I met her through some people I knew. In college, we hung out a bit. Not much because she was in Baltimore and I was in Washington, D.C. But we hung out a bit. After college, I lost contact with her. I probably didn't see Robin again until maybe 7 or 8 years ago, a chance meeting here in Atlanta. But we did not have a consistent relationship from when I left college and came to Emory Law School here in Atlanta. But 8 to 10 years ago, just by happenstance, I ran into her. So she was in Atlanta.
You have been friends with Robin for 30-something years.
Did you hear my answer, madam?
Yes, and I'm asking if you've been friends with her for 30-something years.
I've known her for 30-something years. We certainly hung out and partied together in college. She was from the D.C. area. She would come home, we'd party together. Wasn't close, but she was certainly in the girlfriends that partied together. And then, like I said, I ran into her about 10 years ago in Atlanta, Georgia. But we didn't talk throughout that time period. I didn't see her. I didn't even know where she was. When I ran into her, I was surprised she was in Atlanta. And so, yes, I have known her probably since 1990, 1991, but we have not maintained a consistent relationship that whole time.
For the last 10 years or 5, whatever you'd like to classify it as, have you been friends with her?
I have not spoken to Robin in over a year. I certainly do not consider her a friend now. I think that she, there's a saying, no good deed goes unpunished, and I think that she betrayed our friendship.
So let's narrow it down, the timeline now. So my questions are going to be from the time period of 2019 until she no longer was employed for you, the last time you all talked. So all of my next questions are just focused on that time frame, okay?
Yes, ma'am.
Up until she left your office.
Yes, ma'am.
During 2019, you all were friends, correct?
Yes, we knew each other in 2019.
During 2020, you all were friends, correct?
Yes, we were friends during that time period.
During 2021, you all were friends, correct?
Yes.
Okay. And such good friends that when you needed a place to stay, you asked her if you could take over her lease.
That's a lie.
You did not move into her apartment?
I did, but that's not the way you characterize it. Is wrong.
I asked if you could take over her lease.
I did not ask if I could take over her lease.
Did you move into her apartment?
I moved into her condo in April of 21, but the circumstances around that were that Robin met her husband. They wanted to move into another and separate place. She wanted to get rid of her condo. My father was living with me at the house. Because of this case and because of my stance on gangs, my life was being threatened regularly. My father urged me to leave our home. At the same time, as luck would have it, Robin wanted to give up her lease because she wanted to move in with this new man she met, who eventually became her husband. And so, as life circumstances worked, my dad was begging me to leave the house. He was afraid for me, afraid for his grandchildren. She wanted someone to take over her lease so that she didn't, have to pay a fee or get abandoned. And so, I don't remember when, but probably March or April of 21, I moved in and take over her lease.
And did you pay her or did you pay the leasing agent?
No, I don't even know who the leasing agent was. I paid her.
You paid her. Did you pay her cash or did you use a card?
There were some times that I would give her cash, but mostly I paid her via Cash App. That would be the most convenient thing. So I would not only give her rent, but then like when the utilities would come in, whatever the utility was, she might be like, I need $70, I need $100, whatever it was. And we never had a problem with money. Whatever she told me it was, I never asked to see a bill. I never questioned her. I just gave it to her.
What percentage would you say you paid cash versus Cash App?
Oh, the vast majority was Cash App. I don't know what percentage. I'm not going to guess that. But the vast majority was Cash App. But there would be times she would say, this bill came in at $70. Here goes $70.
Did you have a monthly rent amount that you paid her?
I can't remember. It was $1,400, $1,500. I can't remember what it was. And it would vary, which I don't understand to this day. But like I said, I never questioned her.
When did you move out?
She said it was, that's what I paid.
When did you move out?
I abruptly moved out in February, either late January or early February of 22.
Of 22?
Yes,
February
ma'am.
2022, is that what you said?
February of 22. I believe it is January, but I paid her half the rent of February of 22 is what I remember. And because I was offering to pay the whole rent, even though I didn't live there, I didn't think it was right. And I ended up just paying her half the rent.
So that's after you moved out. You said you paid her half of that. Okay. And the time that you said you had to move out of your house because you were scared, did your dad stay there at your house?
My father was concerned. Yes, we were both concerned.
Okay. But he remained there.
My father was 80 years old. He would have been 79. He was scared to death of COVID. You have to go back to when this was. My father's an older man. I wanted him to move out. We had some discussions about him moving out, and what he decided was the risk of COVID was more dangerous than the risk of the people that were threatening. Typical man, more worried about his daughter and his grandchildren than his own safety. You'll get to meet him, and you'll understand he doesn't scare too easily.
So his grandkids were living at the house as well at that time?
Well, I don't know how old your children are, but when you have adult children, they leave and they come back. They leave and they come back. So there have been periods of time that they're there, they come, they do whatever they want to do. Children do what children do. As long as their mother has a house, they'll come to it. Unfortunately, now the threats because of this case have gotten so extreme. I just pay a mortgage and no one lives there.
And that's what I was going to ask you. So when you moved out in, I think you said April 2021, you left your dad and your 2 kids at the house?
My dad and my 2 kids were not at the house.
They were not? Okay, so they didn't still live at your house?
My youngest daughter certainly did not live there. Okay. My oldest daughter would come back and forth. I can't say month for month when she was there or when she was not there. I know that she has been there post me moving out. At this time, no one is at my house.
So at some point after you moved out for the safety reasons, at least one of your children did come back.
Ms. Merchant, can we get to either the relationship or the financial benefit?
Yes. Let's see. We were back at 2021. So you were still friends with Miss Yeardy then. Were you also friends with Mr. Bradley?
I've never been friends with Mr. Bradley.
You've never been friends with Mr. Bradley?
No, I don't. I don't consider us to be friends. I don't dislike Mr. Bradley, but I don't consider us to be friends.
Is he someone that you would have in your phone and you would message with?
I might have text messaged him.
Okay. Would you text message him and Mr. Wade on the same conversations?
I don't recall doing that, but if it happened, it wouldn't surprise me.
Okay, so that wouldn't surprise you, the 3 of you. Okay. How frequently would you think that the 3 of you would have texted?
Not very. I wouldn't think very often, but you're asking me to recall. I don't even know what time period you're asking me to recall, but I'm not going to speak to that because I just really don't know the answer to that. So I don't want to speculate as to how often that would happen. But it's not out of my practice to text 2 people on one text message. So if you told me that happened and showed it to me, it wouldn't surprise me, although I have no recollection of it.
But there would be some record of it in your phone, or the phone records would have some record of those texts.
Perhaps.
Talk about, you said that sometimes you paid Miss Yeardy cash.
I'm sorry.
When you went on vacation with Mr. Wade, let's just go one by one. Let's start with the first one. What's the first time you went on vacation with Mr. Wade?
I think the first time we went on vacation was around April of 22, and a vacation is a stretch, but I'm trying to be comprehensive. I recall April of 22. His birthday is March the 18th. So that would have been his 49th birthday. I took him to Tennessee for the day. I think we went to a museum. I think we might have stayed the night. I'm not sure. But, Tennessee's kind of hard to call a vacation, but I just am trying to be inclusive. And like I said, I know it wasn't more than a day.
You didn't spend the night?
I think that we did. That's what I'm telling you. I think that there's a possibility that we stayed that night in April of 22.
Who paid for the hotel?
I think I did. It was his birthday.
And would you have used a credit card?
Probably, maybe a debit.
And when did you start dating?
When I started dating Mr. Wade? It was right around then.
April 2020?
2022. Yes,
2022.
it was around there. I don't know, like, it's not like when you're in grade school and you send a little letter and it says, "Will you be my girlfriend?" and you check it. I don't know the day that we started seeing each other, but it was early 22 is my recollection.
Okay, early 22. And you all went to Florida on vacation as well?
I don't recall going to Florida on vacation with him.
You never went to Florida with Mr. Wade?
When we went to get on the cruise ship, we went to Miami.
Okay, that's the only time that you went to Florida with him?
I think we went to Miami and spent the night. That's my recollection.
Okay.
I think we spent one night so that we wouldn't miss the ship. That's my recollection of our vacation.
Paid for that hotel?
In Miami?
Mm-hmm.
I don't remember that.
And how'd you get to Miami?
We would have flown. And we've done that, so that I'm clear, we've done that twice. I think one time we stayed, and I honestly can't tell you, did we stay when the ship left or did we stay when the ship came back? I also can't tell you, so there's 2 cruises out of Miami. There's one that's in that October time period that was with his mom. And then there was another that was a New Year's Eve trip. I know I paid for the New Year's Eve trip because the tickets were $697 each, and I thought this is ridiculous that the tickets are $700 to go to Miami, but when you travel during New Year's Eve, they get you.
So let's just back up and talk about the first time that you went to Florida with Mr. Wade. That was the time that you said you stayed in Miami at the hotel the first night?
That's the time I told you I am not sure. So I'm not sure of 2 things, so I want to make sure that my testimony is clear. I'm not sure if we stayed in Miami on the October trip. I'm not sure if we stayed in Miami on the December trip. I just can't remember that. And I also don't remember, so that the record is clear, I don't remember if the necessity was as we got on the ship or we got off the ship. But I do remember there was a night spent in Miami because either whatever. I don't remember. But I think that there was a night spent in Miami.
That cruise is the one that you took in October, right?
Ma'am, if you have something to refresh my recollection, I'm intentionally trying to not be difficult with you, but I don't want to make up something.
Right.
I know that on one of those 2 trips, we stayed in Miami. I am not sure right now. You're asking me about...
Oh, I'm sorry, you misunderstood. I was not asking you which night you stayed in Miami. I'm asking if you took a cruise in October 2022 with Mr. Wade.
Yes, and his mom.
And his mother. That's what I was asking.
Yes.
Is that the first time you met his mother?
Yes.
It was on that cruise, and that was Royal Caribbean, I believe?
I honestly don't remember what ship. I know we've taken 2 cruises. I don't know what the ships were.
But he paid for the flight and the cruise on Royal Caribbean that time.
So yes, he paid. He is the original one that does it. He has something called, Mr. Wade is a world traveler. I'm not as versed as him. He's been to 6 of the 7 continents. And so he has both a personal travel agent and he also has a cruise travel agent. I don't know anything about either of those kind of travel agents. So he is the one that would book the travel, but we need to be clear when we're talking about just because he booked it doesn't mean, like, I don't consider him having taken me anyplace. Let me just be honest. The only point that's ever taken somebody someplace is for his 50th birthday. I consider that I took him to Belize. And I took him to Belize because, I don't want to discuss his personal business, but I'm happy Mr. Wade is still here with us. And I did 50 big, very big.
So still on that October Royal Caribbean cruise, even though he had a travel agent. I'm sorry?
If you do me a favor, I don't know what cruise ship, what time. So if you'll help me and say October cruise with Mama or the New Year's Eve trip with his sisters, I'll be able to, we can communicate. I just don't know what ship.
October cruise with Mama. That's what I'm talking about.
Yeah.
He paid for the cruise and the flights for that trip.
So he called his cruise agent and he booked that through them because he has a cruise agent.
Right.
He also has a regular agent. I don't know the cruise agent's name.
So I wasn't asking about his travel agent. I was just asking if he paid for those.
He did not, though.
Okay.
Because the reason I consider that he did not is I gave him his money back.
And I was about to ask that. But initially, he paid for them.
Yeah, he called his cruise agent. Like, I think they have his card on record. They do whatever.
Okay. So initially, he paid for the cruise and the flight to Miami and the Royal Caribbean cruise.
And my understanding of that October cruise is like it was a package the lady did for him.
Okay. And I'll get to the reimbursements and all that. I'm just trying to confirm he paid for the flight and the cruise in October.
And I think that when you say things that way, I want this record to be
Initially.
abundantly clear that he calls his travel agent, he calls his cruise agent. They do whatever he tells them. He's like on a first name basis with these people. They do it, and then he tells me how much it is, and I give him the money back. I don't, just like you're asking me about the money with Robin, I don't do my friends like that. So if you tell me it's a G, then you're going to get $1,000. If whatever it is, I didn't ever make him produce receipts to me. Whatever he told me it was, I gave him his money back.
Isn't it true that he paid for the cruise and the flight on his credit card? I'm not asking about reimbursement or after. He used his credit card to buy the cruise and buy the flight, correct?
I have no idea how he paid for it, if it's a credit card, if it's a debit card, but certainly he called his cruise agent. You know, like how many people have a cruise agent? He calls his cruise agent, tells them where they want to go. They tell him what's booked. And you have to remember, he paid for, that initial was me, him, and his mother.
And then after that cruise, you all flew to Aruba and spent a couple days in a hotel there, correct?
Right, and his mother was not happy
He
that we left her
initially
behind.
paid for that. He initially paid for that.
For Aruba, yes, ma'am.
So let's talk about both of those. I know he initially paid for it. Did you pay him back?
For the cruise and for Aruba, yeah, I gave him his money before we ever went on that trip.
You gave him cash before you ever went on the trip?
Mm-hmm.
Okay. And so when you got cash to pay him back on these trips, would you go to the ATM?
No, lady.
You would not go to the ATM?
No.
Okay. So Fulton County pays you direct deposit, I assume?
Yes, Fulton County and the state of Georgia both pay me direct deposits.
Okay. So the cash that you would pay him, you wouldn't get it out of the bank?
I have money in my house.
You have money in your house. So it was just money that was there.
When you meet my father, he's going to tell you as a woman, you should always have, which I don't have, so let's don't tell him that. You should have at least 6 months in cash at your house at all times. Now, I don't know why this old black man feels like that, but he does. When we were growing up, my daddy had 3 safes in the house. So my father's bought me a lockbox, and I always keep cash in the house. Now, I don't do it to the degree that my father would do it, so he would probably be ashamed with me, but I always have cash at the house. That has been, I don't know, all my life. If you're a woman and you go on a date with a man, you better have $200 in your pocket, so if that man acts up, you can go where you want to go. So I keep cash in my house, and I don't keep cash as good in my purse like I used to. I don't go on many dates, but when you go on a date, you should have cash in your pocket.
So my question was, where did that cash originally come from, if it didn't come out of the bank?
Cash is fungible. I've had cash for years in my house. So for me to tell you the source of when it comes from, when you go to Publix and you buy something, you get $50, you throw it in there. It's been my whole life. When I took out a large amount of money on my first campaign, I kept some of the cash of that. Like, to tell you I just have cash in my house, I don't have as much today as I would normally have, but I'm building back up now. So you just put money in. It's a very good practice. I would advise it to all women.
So you can't identify when you came into this cash or where the cash came from?
I didn't say I couldn't identify it. No, nobody gives me anything. I am sure that the source of the money is always the work, sweat, and tears of me. What you asked me for is, when did the money go in there? What I am trying to tell you is, so I got divorced in 2005 from my husband. No. It's important. You said, where did the money come from? And I need to tell you where the money came from. And so for many, many years, I have kept money in my house. That money in my worst days has probably only been $500 or $1,000. At my best days, I probably had $15,000 in my house at cash. At all times, there's going to be cash in my house or wherever I'm laying my head.
The money that you paid Mr. Wade, the cash, in October of 2022, you do not know where that money came from?
I do know where it came from. It came from my sweat and tears.
You know which job it came from? Did it come from Fulton County or did it come from a private job?
It came from, what are you talking about? So it could have come from a private job, because before I was DA, I was in private practice. So I earned money during that time period that's probably in there.
You don't know
could have. What do you mean I don't know where it came from?
I understand the situation. We can move on.
Okay, thanks. Same with Aruba. You don't know where that cash came from either, right?
Ma'am, you are mischaracterizing my testimony greatly. I'm not going to allow you to mischaracterize my testimony. I know that I keep money in my house. The amounts of money I gave Mr. Wade, it was never that serious. I don't think I've ever handed him more than $2,500 in a reimbursement. So we're not talking about $20,000 in cash. I don't have $20,000 in cash right now. The most I ever gave him, I know I gave him $2,500 when we went to Belize, because we went to one hotel and then we went to a second hotel. That $2,500 I actually gave him while we were still in Belize. I know that the Aruba trip, the one that you described with his mom, I think I gave him about $2,000 for that trip, for like total.
His mom went to Aruba with you?
The Aruba trip, so I consider that to be one trip. So we got off of a cruise ship and then we went to Aruba, which is why I cannot remember is that the time that we had to stay in Miami to wait for the flight for Aruba. So I consider that one trip, that we didn't like come back to Atlanta and leave. We flew down to Miami. We got on a cruise ship. We spent a couple of days with his mama. We came back to Miami. When we came back to Miami, either that day or the next day, we flew to Aruba. We spent a few days in Aruba and we came back. That was really one trip. Even though we went two places, it was one trip.
So let's talk about the California trip. Is that when you were moving your daughter out to California? When you all went, or did you have two trips to California?
My daughter doesn't live in California.
Did she ever live in California?
I'm not discussing to you the location of my child.
So how many times did you go with Mr. Wade to California?
Once.
And you all stayed in Napa Valley and he paid for the plane tickets and the hotel?
He paid for the plane tickets and the hotel.
And what did you pay for on that trip?
I gave him much less cash that time, probably $400 or $500, and then I paid for a bunch of stuff. I think we did 2 different wine tours that you do, which are pretty expensive. I think I bought him, he likes wine. I don't really like wine, to be honest with you. I like Grey Goose. I bought him a bottle of wine while we were there, and the sippings that you do. I can't remember how many, like 4 or 5 different places you go. I remember we went to this place that they do pairings. That was the most expensive thing that I think that we did while we were there. So they would pair champagne, chocolate, and caviar. It was a 3, and it was like 3 different things: Sweden, Russia, someplace else. I'll make that up. But that was the most expensive thing we did that trip, and I paid for that.
You pay cash?
For us doing that? Mm-hmm. Yeah, I think that trip did not cost me a lot of money. I might have took like $750 in cash on me because we weren't gone very long.
I'd only asked if you paid in cash. I don't even know the amounts.
When I travel, I always take cash.
And is the cash that you keep in your house, or do you keep it at the condo that you were living in?
So at that point, it wouldn't be at my house, and I'm sorry if I was not clear. The money would be wherever I laid my head. So I wouldn't leave the money at the house. So if I was unclear, no. Money's going to be where I stay.
How much did you pay for your trip to Panama?
To where?
Panama, I believe.
I didn't go to Panama.
I may have the location wrong.
I never went to Panama.
So
Mr. Wade went to Panama with his frat brother.
Oh, he went to Panama with his frat brothers. So tell me about, let's see. So I want to make sure I've got them. I've got Belize. You already covered Belize. You covered the...
So let me tell you our real trips. In October, we went on the cruise with his mom. We got back from the cruise with his mom and we went to Aruba. I consider that one trip. Second trip, New Year's Eve, we went on a cruise to the Bahamas. That's the second trip. I want to make sure I get this right. Third trip, 100% on me. I think he might have spent $200 on that entire trip. We went to Belize. That was my trip. That was, his 50th. And then Napa Valley, we went around May. I don't know the dates, but it seems to me like it was close to Mother's Day.
And those are the only trips?
So that the record is complete, I can remember one time driving to, where were we? South Carolina, and we met my sister for lunch with her man.
When was that?
I don't know, but we didn't stay the night there. But I guess people would consider that a trip if you drive somewhere and you come back. That was insane because it was like 5 hours to drive. We ate lunch and we drove right back. I can remember driving to some little town in Georgia. I don't even know where I was. I had never been there before or after. There's some boat you can get on over to, and there's like a slave thing, if that gives anyone any reference. We didn't do that. I remember doing that. I remember driving one time to Charlotte. We had lunch with one of my very close girlfriends. And again, we drove to Charlotte, met my girlfriend for lunch, and drove right back. So that's a trip. We didn't stay the night there, but I just want to be complete in my testimony. We drove someplace, had lunch, drove back. I don't remember another driving someplace distant for lunch and coming back to Charlotte to see a girlfriend, to meet my sister in South Carolina. We went by ourselves when I told you about that remote place in Georgia. We could have driven someplace else and had lunch and came back, but that's all that comes to my recollection right now. There could have been another place we drove and had lunch. My security team was very clear to me. I'm not to be out and about in Atlanta without them. And so for me to do something just very normal that a normal person would get to do if they weren't prosecuting this case, I got to drive 4 hours to do it.
And that's what I was going to ask you. Your security detail, did they take you to and from your house?
So I haven't been able to enjoy my home.
Condo, I'm sorry.
And March of
where you lay your head. Did they take you to and from where you lay your head?
99% of the time.
Would they take Mr. Wade to and from wherever you laid your head?
That has never in the history of ever happened. Ever, okay?
Your security team has never taken him?
From my house? That's a lie.
I'm asking if they've ever taken him anywhere.
And I'm telling you that that's never happened.
So your security team has never taken Mr. Wade
My security team has never taken Mr. Wade from any place where I have lived and brought him here. Never. Not once. Not ever.
Have they ever taken the two of you together?
To where?
Anywhere.
We've left this building and gone to lunch, but I go to lunch so rarely that is a very rare occasion. I am sure, and let me be clear, it wouldn't just be Mr. Wade. So I'm sure my security team has taken me to lunch. Probably been a time I've left here 7 o'clock, gone to get something to eat, and I don't even know that they would have taken him or if he would have driven himself, but they've taken me to do that. But we're talking very few, very far in between. Most days I don't even eat lunch, and when I do, it's because my assistant has heated up some bag, something, and I eat through meetings and eat in my office. It's not a practice of mine to go to lunch.
During the time period that you were dating, would your security team ever take you two together anywhere?
No.
Never?
If there was a lunch that occurred that I just described, if there was a meal that occurred that I just described, anything outside of that, and it needs to be very clear, not often, once, twice, because I want to be over-inclusive, I'm saying once or twice. I'm not certain that it happened, but I'd rather be over-inclusive with you.
So your office objected to us getting Delta records for flights that you may have taken with Mr. Wade.
No, look. I object to you getting records. You've been intrusive into people's personal lives. You're confused. You think I'm on trial. These people are on trial for trying to steal an election in 2020. I'm not on trial, no matter how hard you try to put me on trial.
So my question was, do you have any problem?
I object to getting any personal records of mine.
We're not dealing with privilege through a witness.
And I'm not, no, I'm not dealing with privilege. What we had offered to put them in camera for the court to review, and I just want to know if she has any
That's
problem.
not something you deal with a witness.
Okay, you have to file as part of your job something called an income and financial disclosure report, correct?
That's correct.
And you filed your first one, so you filed 2 to date, is that right?
Is it 2 or 3? I probably would have filed 21, 22, and maybe I haven't filed 23 yet, because isn't it due like June of the next year?
April, I believe. So you filed, let's see, you filed your first one, it looks like April 15th, 2022, and your second one, April 17th, 2023. Does that sound familiar?
That I don't remember the dates, but you're an officer of the court. I'm going to hope you're telling the truth now.
May I approach the witness?
You may.
Thank you. I already gave the state a copy, Exhibits 20 and 21, if you take a look at those. They're part of the certified records, so you got them.
Can somebody bring me some? Yeah. Guys are getting a little old. Yes.
Okay.
Yes,
so
ma'am.
Those are the ones that you filed.
This looks like me for sure. Yes, ma'am. Yes, ma'am.
Judge, we'd move to admit 20 and 21.
I think you need to delineate which one's which
20
one's which.
is 2021, so it accounts for the time period, Your Honor, January the 1st, 21 through December the 31st, 2021. That is Defendant's Exhibit 20. Defendant's Exhibit 2021, it accounts for the time period January the 1st, 2022 through December the 1st of 2022.
All right. Any objection to Exhibits 20 and 21?
Nope.
No,
Sorry.
From other counsel? Admitted without objection.
Yeah. When did your personal relationship with Mr. Wade end?
Our personal relationship ended in this year. So let's be very clear so that we don't mix words. I don't want to mix words in here. Mr. Wade is my friend right now. Mr. Wade, I would say, has been my friend since 2020. I think he started out as like a mentor and a professional colleague. He became my friend and somebody that I really respected. I feel very indebted to Mr. Wade for taking on the task of this job. And he is certainly my friend and one of the people that I respect the most. So if you ask about a personal relationship, I consider myself to have a personal relationship right now, Mr. Wade. I consider myself to have a personal relationship with Anna Cross. I consider myself to have a personal relationship with Mr. Abadi. I consider myself to have a personal relationship with Andrew Evans.
Okay, let me just clarify that.
I have a personal relationship with him as we speak right now.
A romantic
I don't think that's what you're asking. I think that's what you're asking.
When did your romantic relationship with Mr. Wade end? Did it end?
Me and Mr. Wade, we are good friends. My respect for him has grown over these 7 weeks of attacks. We are very good friends. I think, but for these attacks, it would have been a friendship that, as life goes, you would have stopped having. I think that you have cemented that we'll be friends to the day we die.
Let's.
Could we just have an answer to the question?
I can handle this, Seda. Let's have it.
She asked about a personal relationship.
She asked when the romantic relationship ended. That's the question.
It's sometime in, I'd say late summer of 2023. So I don't believe me in, this is what you're really asking about. This is the salaciousness of all of this, right?
No, I'm just asking about your romantic relationship. When you stopped dating?
I think that me and Mr. Wade, so he's a man, he probably would say June or July. I would say we had a tough conversation in August. And so that men in relationships at the end of physical intimacy, women in relationships when that tough conversation takes place.
And where, when did he come to, I guess, the condo? I'm not sure what you called it, condo apartment. Would he come and stay at that condo or visit you there? I'm sorry, visit you there.
What condo, what apartment? I want to be clear.
So not your house. I know you classified one as house and one as condo, so I'm trying to use those terms.
So, but there's been more. See, what you don't understand is because of this case, I got to move. And so I
Ms.
need
Merchant, if
to.
you could ask a more precise question.
Yes, please give me the time period. That we're
Mr.
talking
Wade
about.
visited you at the place you laid your head.
When?
Has he ever visited you at the place you laid your head?
So let's be clear, because you lied in this. Let me tell you which one you lied in. Right here. I think you lied right here. No. This is the truth,
Judge.
And it is a lie. It is a lie.
Ms. Willis?
You
Mr. Sena, thank you. We're going to take 5 minutes. Be back in 5.
May I go to the bathroom?
Ready, Judge?
Yeah. Yeah, you good?
Great.
All right,
Thank you.
We're back on the record. Before we proceed, though, I'll advise everyone here, this being a room mostly full of lawyers who have spent their lives in and out of a courtroom. We all know what professionalism looks like, what decorum looks like, and devoting ourselves to the rule of law and proper advocacy. I would urge everyone to keep those principles in mind, starting with the fact that we won't talk over each other. And from there, we'll get through this. Ms. Merchant.
Thank you, Judge. How often did Mr. Wade visit you at a place where you were living between 2019 and 2021?
So you want to start with the lie that he lived with me in South Fulton in 2019, a home he's never been to? That's one lie you told in your document. No.
Judge, I didn't ask her about that.
Ms. Merchant, I want you to ask a very precise question. I think she's saying and answering that he did not live with her. So why don't we break that up into smaller parts?
And I didn't ask about living.
But you put in your, while we're talking about professionalism, while we're talking about professionalism, she put in 3 different documents he lived with me.
Full opportunity to respond.
And
filed that with the court.
In 2019.
He's never been to South Fulton. In 2019, I lived in South Fulton. He has never been to my residence in 2019, ever, not once.
In 2019, he's never been to your residence. any place.
I lived in my home in South Fulton before I started getting the threats that were here, a house I paid for with my own sweat and tears. I'm no longer able to live there. But in 2019, I did. And in the 2 months of 2019 that I knew Mr. Wade, 3 months, the beginning of October, all of November, and all of December, Mr. Wade never came to my house in South Fulton. Let me help you out. I lived there in 2020. He never came to my house in 2020, let alone live with me, as you put falsely in these documents. In the first 3 months of 2021, when I could still enjoy my home, Mr. Wade never came to South Fulton, and it is certainly a lie that he lived with me.
So in 2020, so you said 2019, 2020. Did Mr. Wade ever visit you at a place that you resided?
He has never been to my home in South Fulton. 2020 was before I knew that a phone call was going to be made and I was going to have to abandon my home. As a result thereof, he never visited, lived at, came to, or has seen South Fulton.
You qualified that with your home in South Fulton.
That's where I lived in 2020.
2020, did he ever visit you at a place that you resided?
Okay. I don't understand. You're going to have to give me guidance. In 2020, I lived in South Fulton.
Okay.
That's the only place I lived in South Fulton. That's before I had to abandon my home, Judge.
All right.
And at my home in South Fulton,
We'll
he never came there, okay? So if you don't come someplace, you can't live there.
Ms. Willis, I'm going to have to caution you. This is going to be the first time I have to caution you. We have to listen to the questions as asked. And if this happens again and again, I'm going to have no choice but to strike your testimony. So we need to break this down. Ms. Merchant's question, I believe, was asking whether you lived anywhere other than South Fulton.
I did not live anywhere but South Fulton, Georgia in 2020. That is before I began my prosecution of this case, and it was my plan to only live there.
Did Mr. Wade ever visit you at the condo that you leased from Miss Yurdi?
He visited that condo, yes.
He did?
Yes.
Did he ever spend the night at that condo?
No.
Just visited?
Yeah, but he did visit for sure.
Did you ever go out to eat together, other than the lunches you talked about, during 2019 or 2020?
I would think that we probably went to lunch, but it wouldn't have been, let me think, 2019. I'm going to say, I don't know, I'm going to say we probably broke bread someplace in 2019. I don't remember it, but it seems like we would have broke bread sometime in 2019. So I'm going to say yes, although I have no recollection. But it seems to me like I go out to eat and drink with pretty much everyone, so I'm going to say yes.
So outside of the vacations that we've already talked about, did you ever go out to dinner with Mr. Wade?
I mentioned to you that
I'm going to object as to what time period. Like we're asking very vague questions. I thought we were treating the witness as hostile under 611. We're no longer doing that. So we're going to go back and forth. We need to be more specific with our questions if we're going to treat her as hostile.
All right, Ms. Merchant, it's not so much. I think you can elect between leading and open-ended questions, but I think we are still wondering about, and I think we need to get back on track of focusing on the financial benefit or the relationship.
And my next question about if you did go out to dinner, who paid when you went out to dinner?
He paid, I paid.
You both paid?
Okay, so let me be real clear. We didn't say, oh, the bill is $102. You give $51, I'll give $51. I don't operate like that with my girlfriends. I don't operate like that with anyone. He caught the bill, I caught the bill, whomever.
Did you ever pay him through Cash App?
No.
You only ever paid him through cash?
Well, yes. We're talking about, I'm very confused
You've
now.
never given Mr. Wade money through Cash App?
No.
The only money you've ever given him outside of a contract is cash.
I didn't give him money in a contract, so that was cute, but I didn't give him money outside in a contract. What happened, no, we're going to answer it since you said it. He worked more hours than he was paid, and the county paid him for the work that he did. So don't be cute with me and then think that you're not going to get an answer.
And I will ask you about the contract in a minute. I asked you about cash. Did you ever pay him anything? And I'm trying to qualify my questions. I'm not talking about the contract with Fulton County that was paid. I'm not talking about that. I'm talking about Outside of that, did you ever pay him anything other than cash?
I've only given him cash a few times in the course of what we're talking about.
So you've
if
never
we
used
would
a
go to
credit card?
dinner,
Let her finish her answer.
if we would go to dinner, I wouldn't give him cash because he paid for dinner or I paid for dinner. I've given him cash only a few times in life, probably 4.
Okay.
Probably the most money I've ever handed him is $2,500. The least amount of money I've handed him, probably between $500 and $1,000.
You never wrote him a check?
Ma'am, I don't have checks.
Okay. So you have no proof of any reimbursement for any of these things because it was all cash, right?
The testimony of one witness is enough to prove a fact.
So my
Are you
question
telling
was, do
me
you
that
have
I'm
any
lying to you?
proof?
Is that what you're intimating right here?
I'm asking if you have any proof that you paid him any of these
The
monies.
proof is what I just told you.
You have no written proof. Is that correct?
So I have some, probably some transactions like in Belize. I probably spent $500 on my card in Belize. I spent $900 on each of our tickets to go to Belize. I did the $700. I probably got some minor expenses in Aruba that would be on a card. But for the most part, for those trips, other than, so the 2 cruises, I gave him money for those before we ever left because they were pre-booked. Let me answer.
Well, the question was if you had any written proof. And so
I've answered you that I've had written proof.
We can move to the next question. If you've answered if you had any written proof, and that was my question.
I want to make sure that we're clear that for the 2 cruises,
Judge,
and that's
I
the
asked if
cruise
she gave
plus
him written
Aruba.
proof.
We're not going to talk over each other. Ms. Merchant, she answered your question, so we can ask the next question. Ms. Willis and Ms. Cross will have plenty of opportunities to let you clarify your answers when it's her turn.
Thank you, Judge. Knowing your role as district attorney, you know that public funds are scrutinized and money is scrutinized and things like that. You understand.
I'm sorry, go ahead.
You understand you're under a microscope. You have reporting requirements, all of those types of things. You have no record other than your testimony of the money that you've given Mr. Wade.
You've already asked that question. Let's keep going.
When you took office, you had a tax lien of $4,600. Did you pay that with cash when you made that tax lien whole?
I probably paid through however you pay.
Okay. So, but you were saying that you had amounts of cash. You still had that lien in 2022 when you were dating Wade and going on these trips. So the cash that you gave him, that could have been used to pay this tax lien off?
You gonna tell me how to pay my bills?
I'm going to object. This is not relevant as it relates to why we're here today.
Ms. Merchant, are you trying to establish that she was insolvent in some way?
I definitely was trying to establish that she did not have these mass amounts of cash that she's talking about, yes.
All right. Re-ask the question.
You had a tax lien in 2022, $4,600.
Did you say I did?
And you did not use this cash that you had to reimburse Mr. Wade to pay that off, correct?
No.
Okay.
I went shopping too when I didn't pay it off.
And you talked about, you gave a lot of interviews to some authors of a book called Fani Willis, right?
I would not characterize it as a lot. I probably have spoken to them
No, I'm
2 or
gonna
3
object.
times.
My question is relevant as to.
I think it's already come up that finances are discussed in the book. I'll overrule that.
Thank you.
Ms. Wilson, you can continue your answer.
What came up with Mr. Wade as it relates to hearsay statements that he was asked about in relation to what Ms. Willis may or may not have said in relation to an author. So it's not relevant to the testimony that's occurring at this time.
I think Ms. Merchant has said that inside the book, she also makes a statement as to her own finances, and that's at issue.
So you gave interviews to the authors of this book, correct?
Once or twice.
Okay. And
3 times just to be comprehensive. I don't know if it was 3 times, 2 or 3 times, I think.
you were quoted in the book, and I will give you a chance to say if this is a misquote. You were quoted, when they asked you about if you wanted to run for office for DA, you were quoted, "I really don't want to be financially effed up again." Do you remember saying that?
So what that refers to,
My question first is if you remember saying that.
I remember saying something similar to that, but I would like to be able to explain what that's in
fine.
reference to. That's not in reference to anything else. It was a huge sacrifice to be district attorney in Fulton County. Huge. I was doing just fine. I had a municipal court judgeship that was paying me $100,000 a year, and like you got to show up twice a week. Easiest thing I've ever done in life. I also had private clients that were paying me to represent them. So I was able to have a law practice and that. Raising 2 daughters by myself, there were times in life where things were hard. And so I was telling people, I don't really run for DA. I don't want to run for DA. I'm in a good position right now. I got this easy job that I enjoy, being the chief judge of the city of South Fulton. I'm making money at the law firm, and I'm not sure that I want to make this sacrifice. And why does it always have to be me? Eventually, I prayed. I think that I was the appropriate person. I think that I did that. So when you're referring to that, what I'm saying is, why should I make a sacrifice again? And what I was not talking about is being district attorney. Once you get elected district attorney, you're in a fine financial position. I make over $200,000 a year. What I was talking about is I ran for judge. When I ran for judge, I took $50,000 of my personal money out of my retirement, and that money ended up being lost. And I know when you bet on yourself, you're going to have to bet money on yourself. And so what I was talking about was not wanting to go through the personal financial expense of running for office. By no means did I think that I was going to be financially in a bad position once I won. Let's talk about what I was up against, because it's important to understand that comment. I had a district attorney who had been here for 24 years.
And Judge,
people, it's very relevant as to what my mindset was about this. So I'm trying to answer your question. So what I was saying is
tailored solely to finance.
Right, but it is about my finances. If I didn't, nobody put me in this seat. So I had already run for office once. I had spent $50,000 of my own money running, and it was vamoose, nothing. And so when I'm talking to those offers, I'm talking about the contemplation of the sacrifice of the run, not the sacrifice of once you become DA. The odds were against me. I was likely going to lose the election based on who I was running against. So that needs to be in the appropriate context.
Isn't it true that the authors also wrote, and you can dispute this if you'd like, that you were broke after that race?
The 2018 race.
Yes.
Yeah, that was a hard race. I wasn't broke like I didn't have any. So broke is relative to depending where you are, but that hurt to lose that $50,000. So I'm sure my mental mindset was like, I just gave $50,000 away.
Right. So they characterized it from their conversations with you that you were broke, you had poured your own money into the campaign, and you weren't able to pay your own bills because of your clients couldn't pay their bills to you, and you had a paltry array of family and asset forfeiture cases. It says you were trying to make it month to month. Is that an accurate depiction of your financial situation at that point?
I would want to read that, but I don't remember clients not being able to pay their bills. Or
may I approach, Judge?
You can.
You may.
Page 20.
I have not read this book. So like this fact here, her ex-husband Fred had run into a financial. I have no information about that.
I didn't ask you about that.
Okay.
I just asked about if what they represent from their interviews with you, that you were broke and that you had clients that weren't able to pay their bills.
Can you show me where that is? Because this is where you put the tab, so that's where I read.
Broke, couldn't pay their bills.
Yeah, that I'm sure I characterized myself as broke as leaving that $50,000. I don't know that I had her nascent law practice at paltry array.
Well, you just
I didn't have
Ms. Merchant.
I thought I had a law practice. So this is not correct. I'm sure it's just I didn't have any asset forfeiture cases. So I had one case where they had took one of my clients' money at the airport. I don't know if that's what they're I don't know. Paltry array. I did have family law cases. I guess that's what they're talking about. And clients who couldn't pay their bills ain't clients. So no.
So my question was just if this was a fair and accurate representation where it says you were trying to make it month to month at that point in time.
No, I don't think that is actually a fair and accurate representation, but I am certain that after the 2018 election, I'm still not really happy about having given up that $50,000.
You know when you paid your tax lien?
I don't.
You don't? Do you know if you paid it?
I know I've paid some taxes. I don't know. I don't want to speculate.
Did you tell anyone at Fulton County Board of County Commissioners about your relationship with Mr. Wade?
No.
Did you disclose your relationship to anybody at Fulton County?
No, I don't think so.
And as the chief law enforcement officer of Fulton County, I assume that you're familiar with the county code and ordinances?
I've said we're not going to cover that in this hearing, Ms. Merchant.
I'm sorry, Judge?
We said we weren't going to cover the county regulations.
Okay, and I won't. Let me ask you this then. So are you aware that you're required to disclose any relationship with someone that you contract with in Fulton County?
I'm going to object to the court's prior ruling that you made this morning.
Would this be different because it's a potential for impeachment?
Yes.
What did you ask me?
Ms. Merchant, if you could re-ask the question.
Okay. Are you aware that Fulton County requires you to disclose any relationship with someone that you're doing business with?
I'm not aware, and I know often that things are confused with state constitutional officers in county, but I'm not aware.
Okay. So it's not your, so it's your understanding that you don't have a duty to disclose the relationship?
She's answered that question. Let's keep going.
Did you keep track of this cash that you paid him at all?
What are you talking? I don't understand.
Did you keep track? Did you keep a ledger? Did you keep track of it?
So I've only given him cash, as I mentioned, 3 or 4 times. There's no ledger. This is friends handing money off to each other.
So the answer is no, you didn't keep
I think you've already asked whether there was any written proof whatsoever, and she's
Yes.
answered that.
Okay.
So we've covered this. Let's move on.
Who are you referring to when you suggested that Mr. Roman's motion to disqualify was racially motivated?
We already said we're not talking about the forensic misconduct that's been alleged.
And
just so the record is clear, I don't believe I said that his motion was racially motivated, so I don't want that to stay there. I've never said his motion was racially motivated, so that should not be true.
I think it would be best if we don't need to go down that road. We're going to save that for argument.
You once said that you would not engage with a personal relationship with anyone that worked for Fulton County. Is that correct?
An employee?
Anyone that worked for Fulton County.
I think I said an employee.
Okay. So that's the qualification you give an employee? You wouldn't?
I think that's the statement that I made. So if you want to quote me accurately.
So it's your position because Mr. Wade was not an employee? Or it's your position he wasn't an employee, correct?
Mr. Wade is not an employee, and he will tell you that over and over again.
Just 1 moment, Judge. I'm sorry, the statement, just so I make sure I accurately quote you. What you said was you won't sleep with people who work under you. Do you not consider Mr. Wade working under you?
I consider Mr. Wade to be an agent.
An agent?
Yeah,
All right.
An appointee is what I really think of him as.
Your point, whatever merit it has, Ms. Merchant, is on the record.
Thank you, Judge.
Next question. All right. Do we need any moments in a minute? Mr. Sadow.
No, I'm ready to go, Your Honor.
All right.
I'm going to try to ask you questions that you can actually answer without having to explain, okay?
Yes, sir. My comprehension skills are pretty good, so we should do all right.
We shall soon see. If I heard you correctly, you moved into what I will refer to as the Yurti condo in either March or April of 2021. Is that correct?
Sometime between late February and April. Yes, I don't. Just so we're clear, yes. But in that time period, you're in the ballpark. We're in the ballpark.
And is that Yurti condo, would you say that it is in Hapeville?
It is in Hapeville, yes, sir.
And you moved in there for safety reasons?
My father, yes, I moved in there. We were concerned. My father was terribly concerned about me continuing to live at the house. And so they were clear. People came to my house at 5 o'clock in the morning about the police brutality cases, saying I was going to have a wake-up call. There were security threats due to gang cases, and there were concerns due to that was at the very beginning of this, looking into that. And so for all of those reasons and what was happening, my father wanted me out the house, and begrudgingly I left.
Okay, so the answer to the question was yes for safety reasons, correct?
Those were all of the things that caused the safety concerns. I'm sorry.
I'm not questioning whether they are or are not safety concerns. I just asked that you moved into this condo, the RT condo, for safety reasons, right?
Yes.
Okay. At the time that you moved into the condo, be it from February to April of 2021,
Yes.
was your father still living in your house?
Right, because my father.
That's all I ask you.
But I get to explain the answer, sir.
I don't know if there's an explanation. If I ask you, was your father still living at your house, the answer is either he was or he wasn't.
Yes, but you are going to get to argue at the end of this, as we both know.
I'm not going to argue
And so
anything.
I
I'm
would
going to
like
ask.
To be able to explain why.
I'm going
And so,
to.
yes, because my father is an older gentleman, he was worried about COVID and he stayed.
Ms. Willis, I'm going to have to say that's second time. Whenever we have to put a pause, we stop testifying, okay? You'll have a chance to explain yourself. The question was whether your father was not staying there at the time, and you're clarifying that in your answer as well. You can have a brief clarification, but it shouldn't be something that reaches well beyond the question. All right, Mr. Sadal, you can re-ask the question. We'll see where it takes us.
Okay, thank you, Your Honor. Was your father still living in your house at the time you moved to what I would refer to as a Yurti condo?
Yes, sir, he was, due to his concerns related to COVID.
Okay. The safety concern was that there was potential danger at your house. Is that correct?
Yes, my address had been exposed, so yes, there was concerns about potential danger at my house.
Okay, so anyone staying at your house in the time period after you went to the Yurti condo was still in danger, correct?
Yeah, well, no, he did.
I think you have to. It's your attorney, Ms. Willis. Sorry, Mr. Bott, your objection is speculation.
Yes.
To the question of
speculation.
Whether someone was still in danger at her condo.
I can.
Just let her answer the question.
Or Mr. Sadal wants to rephrase.
No,
I'm not sure.
I was able to understand it.
I've got the objection, and then I have.
I'll withdraw the objection. We can move forward.
Okay.
So, and I remember the question, so I can answer it.
But you can, now that the objection's been withdrawn, can you try to answer that question?
Yes.
There's still a safety concern for people staying at the house.
Yes, I was very concerned about my father still living at the house. However, if you have dealt with an older gentleman, he was not leaving the house, despite my urging him that I thought he should leave as well. He did not want to leave the house because he was particularly worried at his age about COVID. But that became, I don't want to say, I was not happy with that decision of my father's, but I can't ultimately make him leave. And he stayed there too long, in my opinion.
Okay, thank you. During that period that you left to go to the Yurti condo, did any of your children stay at your house?
So I don't think that they were there at that point. Certainly my baby wasn't there.
I'm talking about this entire period. We're talking about, if I remember correctly, and you'll correct me, I'm sure, you said that you stayed there at what I would call the Yurti condo until January of 2022, correct?
Yes.
Okay, so I'm asking you, in that period, which would be February to April of 2021 until January of 22, did any of your children stay at your house?
And you don't have to yell at me. I'm able to understand. So I would ask you to not yell at me. That being said, I don't actually expressly remember, but I can tell you, since I have left my home, there have been times my oldest daughter came in. But I can't tell you with certainty the time window that you've said, if they did or not. And so I don't want to speculate to that, but there was some time that my oldest daughter came back. Whether it was that period or after I left the Yurti residence, I'm not sure, okay?
Okay, so if I continue to go into more detail on this, you're not going to be able to give me an answer of whether or not, in fact, any of your children were still at the house or stayed at your house during that time period, correct?
What I can give you clarity of, so that we are clear, is from the time I moved out in February-ish of 2021, after I left there was a time period that my oldest daughter came back. But if you're asking me, was it in that window or after, I just don't have a recollection of that, because, you know, your kids come and they go. And so I don't remember the specific time period, and I apologize for that.
Did your children ever stay with you at the Yurti condo?
Like maybe a night.
Okay.
like for a girls' night or something, but live with, no.
Okay. Did anyone else stay with you at the Yurty condo,
That was
including Miss Yurty?
Never. Miss Yurty never lived in the condo. She met her husband and they moved. They weren't quite married, but they moved. Nobody ever lived with me in the condo. That was
My word was stayed, not lived. Stayed with you at the condo.
I guess I don't understand the distinction, but no one ever. I think my baby, my oldest child, I think she spent one night with me. Maybe my oldest and my youngest, but I think that whole time I was in that place. Other than that one night, I don't think anyone ever, this was a very lonely period in my life. I don't think anyone ever spent the night other than maybe one night. I remember a picture of my baby sitting on the couch in that place, and I'm thinking she spent that night. But just a very lonely time in life.
Okay. We'll stay with the lonely theme just for a minute. Did Nathan Wade visit you at the Yurty condo from the time you moved in until he was hired on November the 1st of 2021?
So I moved out of that condo, but during that time period, I'm sure he came to visit. He came to visit. I can remember us going, I think the restaurant's Lickety Split. I can remember him picking me up, going to Lickety Split and ordering some food and coming and sitting at my table and eating. So I remember times that he visited me at that condo, yes.
Okay, could you give us an approximation of how many times Mr. Wade visited you at the condo between the time you moved in and prior to November 1 of 2020?
I don't think often, but I don't want to speculate.
Can we say more than 5, more than 10?
I'm going to tell you the problem I'm having here. Let's say more than 10, but I'm not sure that that's even accurate. He certainly has come and picked me up, gone to grab some food to eat. I don't remember him being in that condo a lot.
Okay, that's your.
I'm sorry. You want a number, and what I don't want to do.
Giving me your current and best recollection is all I'm asking for.
That's all I can give you, sir.
How many times did any of the prosecution team? How many times did Anna Cross come to that condo between the time you moved in and November 1st of 2021?
I don't think Anna's ever been to that condo.
What about any other prosecutor that's involved in the prosecution of this case?
I don't think any of them have.
Just Mr. Wade?
That's correct, sir.
But it was a lonely time.
Oh my God, that 2021, I have a lot of guilt about this time period in my life. Let me tell you why. But yes, it was a lonely time.
Okay.
I was very appreciative to the citizens for giving me this responsibility and this duty. But what I very, very quickly learned is that this is a very isolating job, and 2021 was a lonely time. I turned 50 in 2021. That's probably one of the worst birthdays I've ever had. I spent it alone. So I have a clear recollection of 2021 being lonely.
Okay. Did Mr. Wade ever visit you at the condo, the time period I'm talking about, prior to November of 2021, when Miss Yurty was at the condo?
So Miss Yurty and me, we didn't share the condo at the same time.
So the answer would be no.
But we never stayed there together, so it's an impossibility.
It's an impossibility.
Yeah.
Okay.
Now, Miss Yurty, because we need to get clarification on this. Miss Yurty stayed in that place. There may have been a time that me and Mr. Wade visited, like went and saw Miss Yurty, but me and Miss Yurty never lived there together. Just so we're clear.
Well, maybe that was clear, but I'm going to have to try again.
Okay.
Was Miss Yurty still living in the condo when you moved in?
Not a day.
Okay. So what I'm talking.
Another misrepresentation in this. We never lived together. I never lived with Miss Yurty.
My question, though, I'm trying to understand that after you moved in to the condo, Miss Yurty she was out of the condo, right?
She got a house.
That's all I'm asking. She's not in the condo.
We never stay, Miss Yurty and I never stay a day together in the condo. All of her stuff was out of the condo, and all my stuff, some of my stuff, not all of it obviously, was moved into the condo. So we never stayed there together. No, sir.
All right. So when I asked you about Mr. Wade visiting the condo when you were staying there.
Yes.
Ms. Yerty wasn't staying there, correct?
That would be correct, yes.
She wouldn't be at the condo, correct?
No, she would not have been.
It would be you and Mr. Wade alone at the condo, correct?
Yes.
That is, there weren't any other witnesses to Mr. Wade and you at the condo, correct?
Yes.
No security, none of your security detail.
I'm going to object. She said it was just her and Mr. Wade.
You made your point, Mr. Sadow. Let's move on to the next one.
Yes, Your Honor. Who in the prosecution team, prior to, I guess, the motion being filed by Defendant Roman, who in the prosecution team knew of your personal relationship, and now I'm talking romantic, with Mr. Wade?
So, sir, I am extremely private.
All I ask is who knew. It's not. If the answer is no one knew, that's fine.
No.
I ask you who knew.
You
Let me just tell
answer
you
it and
this.
then explain, Ms. Willis.
I am very private. When I supervised Mr. Body and Mr. McAfee, they didn't know who I was dating, but I can assure you I was dating somebody. So that I kept something private, that's my private life, is not any mystery to anyone. It's like a woman doesn't have the right to keep her private life private. And I'm speaking on this because there have been all these intimations.
You still haven't answered the question, Ms. Willis.
I'm sorry, what was the question, Your Honor?
Is there anyone else who knew about it? And then you can explain.
I don't know. I don't think so. I certainly didn't go out telling my business to the world.
Okay, so, the best of your recollection, you didn't inform anyone on the prosecution team that the individual that you had chosen to lead the prosecution team had a personal relationship with you.
So
Is that correct?
That's inaccurate. Your question is inaccurate.
What?
Because you stated that the person I chose, we had a personal relationship. So we had a friendship. We have all these distinguishing factors. Remember, when I chose him in November of 21, first of all, let's get this straight. Mr. Wade was not actually my first choice. That's no insult to him.
Your Honor,
No, it is you because of the way you phrased the question. You said, when I chose him, I didn't inform people of a personal relationship. We have defined personal as romantic. It is an inaccurate way to state the question.
Then I will certainly restate it so it is very accurate.
Okay, and please do not yell at me.
You hired Mr. Wade for the first time on November 1st of 2021, correct?
November of 2021, yes,
Okay.
sir.
Your testimony is, whether one accepts it or not, your testimony is that at the time you hired Mr. Wade, there had never been a romantic relationship with Mr. Wade before you hired him, correct?
Yes, my testimony is that we were very good friends, but we're talking about the sex, so let's just don't.
No, I'm not talking about, I'm saying romantic relationship doesn't necessarily have to be just sex.
Well,
It can
I
be
don't-
dating, it can be holding hands, it can be any of those things that one might call romantic. I'm asking you whether or not prior to November 1st of 2021, there was a romantic relationship with Mr. Wade. That's very simple. It's either a yes or a no.
I don't consider my relationship with him to be romantic before that. I'm not a hand holder, so no.
That's fine. Now, let's move beyond November 1st of 2020.
Yeah.
2021, excuse me. If I understand your testimony, there was no romantic relationship with Mr. Wade until early in 2022, whether it be January or February or March, early in 2022, correct?
I would say sometime between February and April. Yes, sir.
All right. Now I'm asking you about that time period when it became romantic.
Yes,
Okay?
sir. Thank you.
Okay. You didn't see the need, if I understand, to tell any of the people on the prosecution team when you had established a romantic relationship with Mr. Wade that the lead prosecutor, that is the man that was basically giving orders to others, was dating or having a romantic relationship with you, correct?
I'm going to object to relevance at this point, Your Honor.
Mr.
Not
Sadow,
relevant.
relevance?
Just to prove what we're attempting to show that there is an issue on the credibility about the relationship. The failure to have informed anyone anyone on her team that she was having a romantic relationship with the lead prosecutor, I suggest gives rise to that inference. That's the relevance.
The inference that
that they were concealing this because it was not as it's been characterized to the court, and that in fact it started earlier than what they say.
All right, overruled. Mr. Sadow.
I just want to make sure that we're clear. From at least 2020, me and Mr. Wade were friends. At least that time period.
Okay, I'm not talking about...
So no, I want to be clear because my credibility is being evaluated here, right? We were friends. We hung out prior to November of 2021. In November of 2021, I hired him. I do not consider our relationship to have become romantic until early of 2022. Because I don't know a date and time, I'm saying sometime between February and April of 2022, and very early April of 2022, because I know that trip that I discussed with you was like the first week of 2022, that the relationship had become romantic. I hope that answered your question, but I can't have it where, you know, we're saying something differently.
All right, so you've established the timeline as you put it. The question originally was, at that time, did you tell any other prosecutors on the prosecution?
I never tell people at work who I'm dating.
All right, Mr. Sadow.
Okay. Did you take any trips to D.C. with Mr. Wade?
Never.
Did you take, okay, so you have no, what I would call personal trips or business trips to D.C. with Mr. Wade?
I never went to D.C. with Mr. Wade, personal, business, otherwise, never.
Okay, so
I've never been in the District of Columbia with Mr. Wade, or Maryland, Virginia, the DMV as they call it.
So as I understand it, just to be clear, any trips that you would have taken to see D.C.
That was a pretty clear answer.
Huh?
That was a pretty clear answer. She just said no.
Twice.
So do you have a variation or something new to bring up?
I'll ask it and we'll see. Did you take trips to D.C. that were non-business during the time period that this case or this matter was under investigation?
I'm going to object as to relevance as it relates to the matter that we're here before Your Honor.
Well, again, the question already asked is take personal or business trips. She said,
but that was with Mr. Wade.
Business.
That was with Mr. Wade. This I asked her alone whether she took.
Okay.
What's the relevance?
And what would be the relevance of that?
I'm trying to understand whether or not we have an ability to show a personal trip in which Mr. Wade is there at the same time. I understand her answer. Okay, I understand her answer, but we have documents, we have records that...
Your Honor, I'm going to object to the documents, the things that...
Well, this could be something that's maybe not part of the record yet, but if he has I think there have been other things discussed in this case, and they have evidence that Mr. Wade may have been in D.C. at the same time. If you want to ask about that exact specific date, Mr. Sadow, you can do that.
I would reference to the court that was not asked of Mr. Wade. Anything about any trips to D.C.
Sure. And so that's going to limit its merit and impact on credibility. So, Mr. Sadow, ask the question.
So
I understand your testimony is you never took a trip to D.C. with Mr. Wade.
That's correct.
Personal or business.
That's correct.
Were you ever in D.C. at the same time as Mr. Wade?
I was not.
On personal or business?
No, me and Mr. Wade have not been to D.C. at the same time. However, since Mr. Wade has been on this case, he's been to D.C. Since Mr. Wade has been on to this case, I've been to D.C. What has not happened is we have not been in the District of Columbia at the same time. Now, the only thing I'm not sure about with what you asked me is if I've been to D.C. personally, because I got a lot of personal friends in that area, but I know that I have been to D.C. I did an interview at Howard University. I went to D.C. for that. Seems like I've been to D.C. one other time. Oh, I went to D.C. for the Global Summit. Actually, yeah, those were two separate trips.
My next question is based on her opening the door, and therefore I'll just ask it, and Your Honor can decide whether or not it's appropriate. When you went to D.C., did you go to the White House?
I did not go to the White House.
No, well.
Apparently I'm going to get the answer anyhow.
There you have it. Next question.
Okay. You indicated your best recollection was that your relationship with Mr. Wade, the romantic relationship, ended you left it in August of 2023. That sound right?
That's the hard conversation. That's not the.
We've covered this. Next question.
And you characterized it as a tough conversation, correct?
Yes.
Okay. I'm not going to get into the conversation per
We
se.
should.
Well, if he doesn't want to, we won't go there. So, Mr. Sadon, next question.
You know, it's kind of hard to say no when you've got that opportunity. But all I'm going to say is, was it pre-indictment in this case?
So
We know the timeline that the indictment was delivered.
but
Well, actually,
and so that we're
I'll give you
clear,
that.
the
Okay.
physical relationship ended pre-indictment.
And is that when you were talking about the tough conversation?
But I'm not sure that the tough conversation didn't happen until after, but the physical relationship. So I'm sure if you ask Mr. Wade, because he's a male, he would say we ended June or July because physical contact ended then. Just in my mind, being a woman, it's over when you have that like hard conversation. I just think women and men think differently.
And I think the answer, Mr. Sadon, to your question was she's not sure whether it was before or after the indictment.
Well, I'm not sure that was her answer, but let's see if I can get specific.
That is what I said. That's what I said.
I'll let you. Next question, Mr. Sadon. If you need to clarify.
Want to say one more? The romantic relationship ended before the indictment was returned. Yes or no?
To a man, yes.
Well, to a man, yes. To you, no.
She's explained this, Mr. Sadon. She's explained this.
And did the forthcoming indictment have anything to do with that?
Ooh.
Or was it just a coincidence?
Mr. Let's go on and have the conversation.
I've just asked you whether or not it was a coincidence.
Had absolutely nothing to do with this. It's interesting that we're here about this money. Mr. Wade is used to women that, as he told me one time, the only thing a woman can do for him is make him a sandwich. We would have brutal arguments about the fact that I am your equal. I don't need anything from a man. A man is not a plan. A man is a companion. And so there was tension always in our relationship, which is why I would give him his money back. I don't need anybody to foot my bills. The only man who's ever foot my bills completely is my daddy.
Is there anything else you would like to add to that?
No.
Sure.
But I'm sure we'll talk about it further.
No, we're not going to talk about it further.
All right, no back and forth, Mr. Sadon. Next question.
My next question is something that that has to do with what I've characterized as the church speech. Let me just tell you what the question is, because I know that's not something.
Preserve it for the record.
Huh?
You can preserve the questions for the record, but then we'll move on.
That's correct. Thank you. When you gave what I've referred to as the Martin Luther King weekend church speech, you know what I'm referring to?
A great honor of mine. That's a historic African-American church. Yes, I do. Okay.
Did you have handwritten notes with you that you were reading from during the speech?
And on second thought, Mr. Sadon, because you might have a number of questions about this, why don't we just bullet point what you would want to cover on this to preserve for the record, and then we'll move on to the next topic.
Okay.
Since I had laid out before that the forensic misconduct isn't a subject
So
of the
do I
evidentiary
not
hearing.
get an answer for that?
That's right.
Okay. Did you read your speech?
Well, no, Mr. Sadon, for everything related to any forensic.
Oh, you just want me to
misconduct
stay
claims.
out of it now?
We're just not. We can do it in a bullet form if you just want to cover what you would have asked, but it's not in a question and answer format.
Okay, so I should do that at this point, or do it when you're ready?
We can do it right now, so it's fresh on your
I'm going to ask her about, did she prepare the speech? Did she have notes on the speech? Did she read the speech? When did she do this? When did she write the speech? Who was she referring to when she was talking about others? Who was she referring to when she said they? Who she was referring to when she spoke in terms of their, that is, their,
I would love to answer those questions.
Well, Ms. Willis, you could certainly do that in some other format, but for today, that's what we decided we're not going to cover.
Who was she talking about that was playing the race card, and why she didn't tell the people at the church that she had had a personal / romantic relationship with the, all due respect the way it was characterized, the black man that she was referring to, and was the black man she referring to, was that Mr. Wade?
Okay.
That's that area of inquiry.
Noted for the record, Mr. Sadon. Next topic.
Okay. I realize that you've testified that you have no records that with regard to cash payments.
Yes.
Correct?
Mm-hmm.
Would your bank records reflect that you withdrew cash from your bank accounts during the time period of 2020, 2021, 2022, or 2023? I'm not asking you, I'm just asking whether they would reflect that you withdrew cash from any of your bank accounts.
So the exact amounts?
No, just
But yeah,
that
of course,
you did.
Of course, I withdrew money throughout that time period, throughout my life. I've withdrawn money from the bank. Yes, of course.
Talking about cash from, that is, that you go to a
Cash,
bank
right.
or you go to an ATM and you take cash out.
Either that way, or you go to Publix and you overpay, or you go to another store and you overpay. So yes, both through that, yes, of course they would reflect that at times.
Okay, and so those records, if we had them, would show that, correct?
That throughout the course of my life, I took out money.
I was very specific. I said
Yes, during the course
2020.
of that time period, I would have taken money out. Yes,
So, do you have a problem with?
I absolutely. Yes.
You don't want the bank records to be made available for the court and the court
I'm
alone.
going to object as to the relevance, and this has already been addressed earlier as it relates to other records. This is an improper line of questioning. He's doing it for the purpose of harassment, to be perfectly frank, Your Honor.
I'm just going to sustain it on relevance. Mr. Sadow, if that's something you want to follow up privately, you can do that.
Okay. Last area, briefly.
Yes, sir.
You had contact with Mr. Wade in the year 2020, correct?
Ooh, I had some contact with Mr. Wade.
Would you explain when you say some contact? Please tell us, talking about 2020.
I had some contact with Mr. Wade in 2020. One of the reasons your allegations are so preposterous, or Ms. Merchant's that you have joined, is...
Ma'am, I didn't ask you about the allegations. I asked you about your contact. That's all I ask you, okay? I appreciate that you want to say something, but I'm interested in, did you have contacts with Mr. Wade in 2020? And your answer so far has been yes, correct?
Very limited contact because Mr. Wade had a form of cancer that makes your allegations somewhat ridiculous.
I do appreciate the
I'm not
characterization.
going to emasculate a black man, but I'm just telling you.
I'm sorry, what?
I'm not going to emasculate a black man. Did you understand that?
All right,
So I don't
let's
think
get
we should
back on
discuss
track.
further.
Mr. Sadow, next question.
Trying to, Your Honor. Would you tell us on the occasions in 2020 that you had contact with Mr. Wade?
I'm sorry. I thought I had answered that. Yes, sir. There were times in 2020 I had contact, but 2020 was a year I was running for office. It was a year that he was going through some serious medical issues, and I did not have much contact, but I certainly had contact with him in 2020.
Did you go out to eat with him?
Maybe, probably.
Did you visit him in any location, his office, or did he visit you in your office in 2020?
I am sure I'm sure. Ooh, that's a very good question. I'm sure he came to 750 in 2020.
750
was my office.
Okay.
Not often, but maybe once or twice. Maybe I went to his office once or twice, but maybe once.
And the purpose for going to his office would have been what?
Maybe we would have went to Mellow Mushrooms for pizza, or maybe he would have come for lunch. I'm sure we went by each other's office, though, but not often, not a lot. We both grinding, trying to make a living.
Wait, I understand what you've said about the cancer, and I'm not going into that. But when you were going out with him to restaurants, or when he would come to your office, right? Those were not sterile environments, were they?
Oh, very sterile, because it was...
The restaurants were sterile environments?
A lot of times we wouldn't eat there. We would pick up something and go in, but they were...
I'm listening to you. You pick up and take it to where?
Maybe eat at our office, but it did not happen much. That's what I'm trying to explain to you. And my office in 2020, nobody was coming in. I was stir crazy, so I would still go into my office. You remember when I started this, I said, I am not even sure if we came to each other's offices, but I am trying to be over cautious. So I think I can recall him at 750 a couple of times. I just think I can recall him at 750 once, but let's say twice. I have seen his office. I remember all the awards in the lobby, but I'm not sure in 2020 I went. I'm not even sure I went in 2020 at all. I just want to tell you yes, because I'm not sure. But I have a distinct recollection of him at 750. I actually don't have a distinct recollection of me at his office in 2020. But maybe I went to his office in 2020. Maybe.
Did you have ongoing phone conversations during 2020 with Mr. Wade?
Oh, yeah, I talked to, yes, absolutely. Yes.
Yes, no question about that.
No question. I talked to him on the phone in 2020.
I understood, and this is, maybe I was confused. The Belize trip was for
his 50th birthday.
His 50th birthday, and that was in
March. He turned 50 March 18th of 2023. If you look at the dates of the trip, I think we were there about 6 days. We stayed at 2 different locations.
And you paid for it?
100%. He said, not only, I paid for the hotel, I paid for the flights, I had a birthday luncheon for him, I paid for massages, I paid for everything.
And would those payments be reflected on your credit card?
Cash.
You paid them in cash?
Cabs. I was telling you all the different things.
I'm asking you whether or not those payments would be reflected on credit card bills of yours.
So there was about $500 that I think is reflected on a debit card. What my recollection is, I took about $4 in cash with me to that.
400 or 4,000?
4,000. But I remember I handed him 2,500, and then the rest was just the money we spent. I probably gave $300 or $400 to this guy who was a taxi driver. He would drive us every day around the 2 or 3 days we went. Took him to eat like it was my trip money.
And you had, to be clear, to end this up, the 4,000 that you've just told us.
But I didn't give it all to him. Remember, I only gave the 2,500 to him.
I didn't ask you that. I was going to ask you that 4,000 is part of your, my words, cash hoard that you had collected over time.
Cash what?
Hoard, H-O-R-D-E.
Oh, I thought you said something different, sir.
No, I'm afraid I wouldn't say that. Any circumstances to you or in
All right, back on track.
So hoard, cash hoard.
I would not classify it in that way, but I have money at my house. Yes, sir.
Okay. And the money, when you had money at your house? I'm speaking too loosely.
I had money wherever I was staying. So I was not referring to my house in 750. I'm saying I had money wherever I was laying my head. Yes, sir. That was my fault that I wasn't clear.
Okay, so when you were at what we said the Yerti condo during the time period we've always discussed, that's where you would keep your cash?
When I stayed there, yes.
Okay, that's all I have. Thank you.
All right, I want to see if we can get through a few more defense counsel if possible before breaking for today. Mr. Stockton.
Madam District Attorney, I'm Alan Stockton. I don't think we've had the pleasure of meeting.
It's a pleasure to meet you, sir.
Madam DA, you described these various trips, and Mr. Sadow asked you about going to Washington. Did you and Mr. Wade go to New York?
I've gone to New York. I've gone to New York twice since I've been district attorney. I'm trying to think if it's 2 or 3 times. I went to do a domestic violence thing there for sure, and I was honored, and I went to the Apollo there. Those are the only 2 trips that come to mind. I went. He was not with me.
You also said that he was a world traveler and had been on many of the continents.
I've been to 6.
Have you been on any of those continents with him? Besides this one?
Where's Belize? What continent is it? I'm not being funny. I don't know.
Let's say, with the exception of
Belize with him. I've been to the Bahamas with him. I've been with Aruba with him. Don't embarrass me. I'm not sure what continents those are on. Whatever continents those are, that's where I've been. I'm sure if I gave it some thought, I would tell you. But whatever continents those are, that I've been to those locations, sir.
But not Australia or any other continents?
I don't even want to go to Australia. I do know he took a trip in December to Australia. I have no idea, I don't know anything about that trip.
When Mr. Wade began working with your office,
Yes,
he had two other gentlemen that worked in his firm with him. Is that correct?
yes, Terrence Bradley worked for him, and Chris Campbell worked not for him, they worked with each other.
Did you understand what their partnership arrangement was?
No.
Did he ever make you aware of how fees were divided or anything?
No.
Now, since you have been district attorney, the two gentlemen that worked with Mr. Wade and his firm, they also had contracts with your office. Is that correct?
I probably had I don't
know if we've covered this in Ms. Willis, but I still don't know what the relevance would be of her testifying to this.
But I've had about 10 people. Oh, I'm sorry. Do you want me to answer
Let's
or
figure
no?
this out.
Judge, respectfully, I think based on Mr. Wade's testimony, he had an interest in those contracts.
Sure. But how's that been imputed to Ms. Willis?
I don't know whether or not she knew she was giving him that benefit. That's what I was trying to explore.
Okay. Well, maybe we can start with that question, and then if she doesn't know about it, then the ins and outs of all the contracts wouldn't be quite as relevant.
Judge, to lay a foundation for that, though,
Let's see where it takes
I need
us.
to.
Go ahead.
The two gentlemen that were in Mr. Wade's office, did they have what I think's been referred to as a taint contract?
So let me be clear, and I may get the names wrong. When I first became DA, the office was not properly staffed. And so I'm surprised any lawyer would take it, but I did a contract for like $60 an hour to help us out with first appearance. That lasted a few months. Okay, so I can't remember if Bradley or Campbell had that. I'm sure we can have records and I can tell you which one, but I just can't remember now. I liked their experience. Bradley had been a probation officer and a defense attorney. Campbell had been a police officer and a defense attorney. There's a reason I'm telling you this. Then that contract, like I said, it didn't last long. It was just, I was aggressively hiring. As soon as I got where I felt like I had first appearance, enough lawyers for that, I let them go. Then we had what's called a filter contract, but it was not filter for this particular case. I do have a lawyer who does the filter for this election interference case. When we're talking about filter, the contract they had that neither one of them has any longer, I now have another lawyer that does that for me. It was only for police brutality cases. It's for what I call so when I first got to be the DA, I had, the whole unit was called anti-corruption. It dealt with both elections and police brutality cases. I actually took a trip to Houston and visited the district attorney in Houston. They divided their work up, and I thought the way she was doing it was better than me. And so I made a civil rights unit. And so they did what we would classify as civil rights cases. Those are specifically the police brutality cases. When I first took over, I was told Paul had not filtered 5 cases. That was a joke. It ended up being the 101 cases. They weren't filtered, which is why I hired 2 of them. Eventually, we got it down enough that it was 1 of them. And then now I still have 1 lawyer that does it, but now I've been able to cut those cases down to like 30.
Can you tell me help me understand what the purpose of the filter is?
Yes, sir. So what a filter is police officers make statements in the line of duty, and you are not allowed as the prosecutor to know what those statements are if they're done in the furtherance of their employment. And in fact, if you know what those statements are, you're basically disqualified from the case. You can't have it anymore. So what our policy is, I think I pay them like a $50 flat fee. They pick the case up directly from the GBI because that's where those cases go to. And then what they are to do is to go through the entire file. So the body cam, which is important because sometimes they'll make a statement to their supervisor on body cam, in the police reports where they write things. If it would be easy if it was just some statement of the police officer, but what you find out is these statements are embedded in it. And so what your filter lawyer does is they go through it, they either redact it out electronically or they cross cross it out, and then once it is crossed out, then they provide it to my team, and then we're able to look at it. That was not being done appropriately when I became district attorney. I thought that it had only been, so Mr. Howard had some Chinese wall thing that I didn't think worked at all, where allegedly those cases were properly redacted. That ended up being a joke. And so the 5 cases really turned into, I'm not going to say all 101, but a vast majority. That is the work that Mr. Bradley and Mr. Campbell did for me. They did a really good job. All of those cases that we originally came with, they're done. Those cases they're not just done for Mr. Bradley and Mr. Campbell, they're done through my office. But obviously life is not stagnant. There have been new police cases. I do have a lawyer that is doing that work now. That doesn't work for me. That's same kind of deal. I have another lawyer that does filtering for this case, completely separate.
So in the same private office, you had a filter contract, then you had somebody else handling first appearances and so forth, and then you had a special prosecutor. Is that correct?
I'm just not. Ultimately, the answer to your question is yes, but I'm not sure that they did it at the same time. The first appearance contract was either $60 or $90. I don't know really how I convinced them to be able to take that, but I think because it was for such a short amount of time. And then I think I pay my filter lawyers, which I still don't know how I get away with, about $150 an hour. And I want you to understand, the AG pays special prosecutors $1,000 an hour. So I'm a tough negotiator. Paul was paying people up to $375 an hour. I won't pay anyone more than $250 is my max. I have a lot of lawyers a lot for what I have that work at $250, and I cap them every month. You can't go past a certain amount of hours.
Would you agree that if Mr. Wade and the 2 other gentlemen that were in his firm were splitting fees in equal thirds, would you agree that he would benefit from the tank contract and also from the other first appearance contract?
I would agree he would make money. Yeah, so to make money is a benefit.
Just a thought, guy.
Mr. Durham, if you're still with us on Zoom.
No questions, Your Honor.
Mr. McDougald.
I do have a couple, Your Honor, but it's a little awkward from back here. If you want me to...
Yeah, why don't you go ahead and make your way up.
Good afternoon, Ms. Willis. How you doing?
I'm very well. How are you, Mr. McDougall? I think this is our first in-person meeting, correct?
Second.
Second? Well, I apologize for not remembering you more clear.
That's quite all right. I'm referring now to exhibit number 21.
Yes, sir.
Which was your financial disclosure form for 2022.
Yes, sir.
And it has a question which requires you to disclose any gifts or favors from a single prohibited source in the aggregate amount of $100 or more. Do you see that?
I don't, but I believe you.
It would be on page 2 in the middle, paragraph number 3.
Yes.
And what is your understanding of a prohibited source for purposes of this form?
I believe there's some classification of somebody you like don't have a personal relationship with that gives you $100.
All right, if you look under there at subparagraph 2, Romanet 2, it defines it as someone that you know or should know is seeking to do or is doing business with the county, correct?
Yes, but yes.
That includes Mr. Wade as of the date you filled out this form, correct?
Yes, but he never gave me a gift of $100 or more. The only thing that I would say maybe went over that, but I don't think it ever did, is if we went to dinner and my meal was $100, but I don't think I've ever eaten $100 worth of food at a restaurant, because I would not pay him back if we went to lunch or went to dinner. But trips, I paid him back for. You know, I never thought about the money until y'all brought it up, and I would be less than honest that says I was giving him the money back because I was the district attorney. I didn't take gifts from him for a lot of personal reasons. Anyway, I did not take gifts from him.
And so your reason for not disclosing any gifts from Mr. Wade on exhibit number 21 is that the aggregate amount on a net basis was less than $100 in the year 2022. Is that correct?
I did not accept a gift of him of more than $100 in 2022. The one exception to that, because I want us to be clear, is we probably went out to eat multiple times in the year. If you're considering eating a meal, because we went out multiple times, that probably went to the level of more than $100. But if we're doing tit for tat like that, I probably paid for as many meals as he paid for. And so I did not receive any gifts from him.
The question on the form,
I understand the question.
The aggregate in excess of $100, and your testimony is that you did not receive in the aggregate more than $100.
All right, Mr. McDougal, you can sit down now.
I don't believe she answered that question, Your Honor. She answered as to specific individual gifts.
And you're not listening to my answer either, so we're done.
Very well.
Okay. Mr. Rice.
No further questions.
Mr. Gillen.
Good afternoon.
Good afternoon, sir.
A few questions here. I want to. You saw the book here. Find Me the Votes. That was shown to you, correct?
Yes, sir.
Your Honor, I would like to just tender this as an exhibit, number 22.
Is that your copy?
It is.
All right. What exhibit is that going to be?
22.
All right.
I'm making the
is that
evidentiary contribution here to this. Now.
Well, I guess you're tendering it. Is it with position of the state?
I'm going to object to the relevance at this point. There's no relevance at this point.
Mr. Gillen, are you using this to confront her with prior statements?
Yes, Your Honor.
Okay.
And statements that she made concerning her financial situation and laying the foundation for that, and that she gave these interviews to the authors. And so this would document that, and ask her, get this in the record, ask her questions about it.
Well, we could mark it for impeachment purposes. I'm a little wary of entering an entire 300-page book because I don't know exactly what every single line, if it would pass hearsay or relevance or et cetera, et cetera. But I don't think it needs to be admitted as an actual evidence for the record for you to do what you need to do with it. So,
well, Your Honor, I understand. I just would.
It's marked as Exhibit 22, and we'll move from there.
Thank you, Your Honor. Now, you were asked a little bit about this book before, correct?
I think Mrs. Merchant.
Ms. Merchant did.
Asked me some questions, yes.
And you gave about 6 interviews to the authors of this book in the sit-down?
No, sir.
You didn't?
No.
Was it?
She answered how many interviews she gave, in her opinion.
How many, in your opinion, do you believe you gave, and how long did they last?
2 to 3, maybe 20, 30 minutes.
So your testimony is at most, you think that you gave maybe an hour to an hour and a half's interview to the authors of this book?
Oh, you mean in total?
In total, yeah.
Maybe, yeah. Anywhere between, definitely not more than 2-ish hours.
Okay. But you also were telling, when they were, the title of the book, of course, is A Hard-Charging Georgia Prosecutor, a Rogue President, and the Plot to Steal American Election. You've seen that.
Why is the title of the book relevant, sir?
And I had no.
And then I'm going to ask her whether or not that was the theme that they gave her when they talked with her.
What the thing gave her? What do you mean by that?
Well, because they were sat down and they told her why they were there to interview her.
And why does that matter?
Well, I think it matters because it shows, but they want her to give her version of what her life story is. This is almost a life story of her. So that's why it's relevant. But if the court thinks it's not, then
no. It could be relevant to your issue of the forensic misconduct that has been alleged, and maybe some of the motives at play when it comes to forensic misconduct. But I'm not seeing. Again, what we're here for today was the relationship and/or any financial elements of it.
Correct. Well, I think it clearly relevant to the forensic misconduct, also relevant to the personal interest in terms of the finances. Let me.
I didn't make 10 cents off that book.
Pardon me?
I didn't make 10 cents off that book.
Didn't ask whether you made any money.
Okay, I just
didn't ask whether you made any money.
Do you have any other statements that she hadn't already been confronted with by Ms. Merchant?
Well, other than I want to focus on when you were telling them about your financial straits and you're living kind of month to month, that is what your financial status was back in 2018 after your election.
Mr. Gillen, we covered that at length, and you're at the end of the line. I'm sorry about that, but we've got to find new ground.
Well, let me move on to my point here. So the point is that what you're telling us is that you were in financial straits, but really that your testimony today is you had a cash hoard of maybe up to $10,000 in cash where you laid your head at night so that you would dip out and there would be no record of it, correct?
That's not what I'm telling you, sir. That's not at all what I'm telling you. What I'm telling you is that throughout the course of my life, I have always kept cash in my house. That cash has ranged from times, my father would probably be ashamed of this because he would say it should be more, but that cash at times has ranged from $500 to maybe $9,000, and he would be like, that is not what I told you to do. I've always had that amount of money. What I've told you is that when I travel, you do better negotiating when you travel. If you have cash, you go to get the cab. They say, oh, we're going to charge you $300 for the day. Well, I got American cash. Will you take it for $150? And so it's my practice to take money when I travel. We're not talking about a whole lot of money. We're going to the Bahamas. $1,500 in cash is in my pocket, or at the most $2,500. Belize was actually probably the most money I've ever taken. And it was taken because it was a big deal. My 50th birthday sucked. His 50th birthday, it sucked. It was terrible. No.
Your Honor,
and
I'd
so
like to get back to some questions here.
I'm trying to answer it.
I think it would help if we.
So let's move to the specific yes or no's here. Have you told us today that you would keep a cash hoard in your residence up to about $9,000? Yes or no?
And throughout the course of my adult life. And so let's even be more specific than that. Probably from the time...
Your Honor, I'm only asking for yes or no rather than
and we have already covered this, so I need to get to that point. I know you're laying the foundation, but it's already been laid. So
yes.
The filibuster is here. I'm trying to move through the filibuster.
Yeah, but we're not talking about a lot of... And so it could be $2,000, it could be $1,500, it could be $7,500. It just depends on what you're doing at that time. What I'm telling you is when I traveled, I took cash. I find that when you travel, especially to foreign countries, the American dollar does well, and it's good to have cash. You can negotiate with the taxi driver, with the jet skis, and it's not a lot of money we're talking about.
Your Honor,
okay, understood, Ms. Willis. Let's get to a question, Mr. Gill.
And so you have cash in your house, but you had a lien, a tax lien on your property. Is that right?
I don't believe I had a tax lien on my property.
You have a tax lien on your property.
You got to talk up louder, Mr. Hunt. Okay, we already covered that, Mr. Gillen. I need new ground here.
I'm asking the question. I'm trying to figure out how someone can have a tax lien.
Then ask that question.
But not use the money that they allegedly said they have.
Well, I think Ms. Merchant asked that exact same question. She said she didn't use the money to pay her tax lien. So what's your question that's new?
So I was going to build on that to say...
No more building. It's already built.
All right.
It's the same way you pay a bill.
So just put the top on it if you need to, okay?
It's the same way you owe a bill and go shopping.
Well, now, have you ever used, did you say earlier that you used Cash App?
When I would pay Robin Bryant, I used Cash App.
What is Cash App, for the record?
I don't need to know that for the record. Let's keep going.
Well, so if you're paying Robin with Cash App, why aren't you allegedly paying Mr.
There's no alleged here.
Why aren't you paying allegedly Mr. Wade with Cash App?
I don't think Mr. Wade does Cash App.
Did you ask him?
I think he's told me he doesn't do Cash App.
Okay, so that's the reason why you didn't use Cash App.
He's sitting next to me. I hand him the money.
Because there would be a record in Cash App of your making payments, correct?
Yes, but I didn't think that I was making a record in a personal relationship.
Because when you're filing and I know that I'm going to move into this financial statement here. You were asked just a second ago about your non-disclosure form, or your disclosure form of an Exhibit 21, where we agree that Mr. Wade is a prohibited source, correct?
What I agree to is I don't believe he's giving me gifts. You would like to classify these trips as gifts, but I've always paid my fair share on these trips, so I did not look at them as gifts. I don't think that what this is disclosing, and they can tell me if they mean something different, I don't think it means that if you go to dinner with somebody over the course of a year and it gets to 100, you're supposed to report it. If my understanding of that is wrong, I've probably been to lunches with a couple of people that over the course of a year they paid, I paid.
Prohibited source means...
We already went over this, Mr. Gillen. Mr. McDougall.
Well, Your Honor, I have to lay the foundation here before I can follow up with my next question.
I don't know why you have to.
Well,
it's the questions have been made.
Then your 2022 disclosure form did not list any of the thousands and thousands of dollars that Mr. Wade paid for on trips that you were on. Isn't that correct?
That's because Mr. Wade was paid that money back, or he was paid due to the fact that I bought the plane ticket or I paid for the hotel. There were never money that he gave me. That wasn't the nature of our relationship. You know, there's so many men, and Mr. Wade is one of them, where the nature of the relationship is they're just paying a woman. The nature of our relationship is companionship and friendship. Despite the way people would like to paint certain women, it's just not true.
Final question. And not a single solitary documentary piece of evidence showing that you have withdrawn the cash to pay him back.
All right. Thank you, Mr. Gillen.
That's not accurate.
Thank you.
Okay, Mr. McCullough, on behalf of Mr. Floyd. All right, and Mr. Cromwell on behalf of Ms. Latham.
The great thing about coming last is most of your questions. I had one question, Ms. Willis. Can you hear me?
Yes, sir.
In the time period between February of 2021 and January of 2022, while you were staying at the Yurdi condo, did your father ever come and visit you during that time period at the Yurdi condo?
He did not.
That's all I have. Thank you, Your Honor.
All right, Ms. Cross, I would imagine you have a number of topics to cover with Ms. Willis that'll take more than 10 to 15 minutes.
I do.
Okay. Then I think we've reached a stopping point for today. And so, Ms. Willis, I'd ask if you can step down now. And I'd also remind you that you're not to discuss your testimony or that of any other witness until tomorrow morning. We'll be back here, and we'll begin again at 9 a.m.
9 a.m.
We'll do 9 a.m. this time tomorrow. Before we recess for today, I want to check in on logistics, and I'll ask Ms. Merchant. Once the testimony of Ms. Willis is concluded, how many other witnesses do you anticipate calling?
And then we subpoena Delta records, but the state objected. So.
We can handle that now. Ms. Willis, you can step down. You're done for the day.
You want me to leave the courtroom?
Or you can sit at the counsel table. We don't need you in the witness box. All right, so 2 witnesses, and then querying other defense counsel. I know Mr. Gillen, there was a potential witness that was objected to by the state, so there's another one there, and we can talk about that. Were there any other witnesses anticipated from any defense counsel? All right, seeing no show of hands, and then Ms. Cross, any witnesses on your behalf?
I expect so, Your Honor, and I expect that to take 4 to 5 hours.
Okay, and how many witnesses would you imagine?
Without committing myself to a final number, my best guess at this point would be 3 to 4.
Okay. All right.
Do we know who? I mean, I gave them our witnesses. I know we're supposed to give witnesses from evidentiary hearing. I'm guessing that one is John Floyd, but I don't know anybody else.
All right. No, I understand, Ms. Merchant. However, I don't think at this point there's any statutory requirement. We have the standing order that, for expert witnesses, and if state doesn't want to extend that courtesy, then I think you're stuck with it. All right.
I'm certainly happy to represent that Mr. Floyd will be a witness, that the other witnesses will be impeaching of Ms. Yearty.
Okay. All right. Let's take up these last couple issues here before we break. Then the issue of the Delta Airlines records. The motion to quash was filed by the state on behalf of Ms. Willis, I believe.
I didn't file a motion, Your Honor.
Oh, excuse me.
But my representation was that I just got notice of them, I think it was yesterday.
Okay.
And so now that I've had the review of them, I object to the general fishing expeditions. I've introduced a new record today that was from Delta. To my knowledge, that there's going to be no further new production in the Delta records. I don't want to burden the court with anything. If the court wants to take a look at it and see if there's anything different than that, I don't have an objection. I don't like the idea that we're just looking for anything. I don't want to put an obligation on the court, but I'm happy to agree to it in camera if that's the court's interest.
And so, Ms. Merchant, I take it.
Tomorrow 5 points.
All right. So, Ms. Merchant, I take it the purpose of this subpoena.
Martin Luther King Jr. Drive Southwest.
I'm going to need you to step out.
Step out, ma'am.
So the purpose is to show travel.
Right. Is it because you suspect there are other travel records, or just you think there might be something else in there?
It's, well, one is to prove some of the travel records that they traveled together. And so we have no problem, like I told the state, putting the camera. I don't even
I mean, what I'm saying is if we've heard about the trips today in detail. Is there anything else that's in these records that you're saying is going to prove some additional trip, or is it just further corroborating what really is kind of uncontested at this point?
there may be some additional trips.
But you don't know of any specifically. You just think there might be any. Okay. All right. Well, then let's continue with that. Then, if you want to send them or instruct Delta to send them to us in chambers, we'll take a look. And I think essentially, if there's, you can tell us, Ms. Merchant, what you think we should be looking for and what you think is relevant, and we'll do that. Okay. All right. And then when it comes to Mr. Schaefer's witness, there was an issue raised about this kind of being a summary versus an expert witness, and so I reviewed the motions, and I think there was the essentially kind of the summary document that Mr. Gillen's witness would, the sole purpose of this witness to introduce. Was there something about, I don't know whether it's from Mr. Abadi or Ms. Cross, was there something about this attachment substantively that you think is inaccurate, or is it literally just a summary document?
I can't tell, because the documents to support it were on a thumb drive, and there's tens of thousands of those documents, and so I don't know whether that is accurate or not. I can point to some characterizations on it that I would quibble with.
Sure.
I think the result is wrong, but I just can't agree to include the documents or someone testifying from the documents that I just can't verify. It may well be that there isn't anything ultimately, but I can't represent that, and I can't agree. The document itself isn't authored or identified as being authored by any particular person.
Okay, give me a second while I pull it back out. So what I was provided by Mr. Gillen is a 3-page document. It starts with a timeline, usually dates, events, and sources, and it ends with an Excel sheet with some more figures. And Mr. Gillen, what do you have to say on this?
What we would intend to call Bill Selensky as a summary witness, not expert, not giving expert testimony. And what we've done is that we have, and we got the bulk of sort of what was in the download we got last week as a Schaefer team. So what we have here is the source information over here. If we look at that, Your Honor, that's largely, all of this information essentially is material that is material of Mr. Wade's. This isn't something that's some different company or bank account. And largely what it is a situation where, as it now stands, most of these source documents are already in evidence. And So, whether it's 1006 or frankly a demonstrative aid under 611.
Well, that's what I was about to say. Why couldn't this just be used as a demonstrative? What would the state's objection be then if Mr. Gillen was just to say in closing, hey, I put all these records together and here's my demonstrative?
I don't think I have an objection to that. I might quibble with some characterization in some language.
Sure.
But to call it a summary and to represent that the records is an accurate reflection of the records, I just can't agree to because there's so many records they were disclosed on Wednesday, and I just don't know.
Well, except, Your Honor, if you look at the sources, I mean, literally, we're describing things that were introduced today. They've seen all this. And the documents that we have sourced really came from Mr. Wade in his divorce case. So it's not like they're surprised. So we would ask that the witness be allowed to testify and just put it in the record and put the summary charts in the record and have them admitted. And that way, off we go. This isn't a situation where we have a jury and they're overwhelmed with whether or not there is some kind of factual misunderstanding here. They could look through this probably at lunch and determine whether the source is accurate or not. The second sheet, Fulton County payments, that came from them. So to say if they can't determine or decipher whether the documents they gave to us is accurate, doesn't seem to carry the water. This isn't a situation where we have tens of thousands of new and different documents from different corporations, different banks, and then suddenly we've put it on. We've done our best. We got these things last week. I've gone through them all, and we've called it down to what we think is a very concise summary chart for the court's consideration.
All right. So, Ms. Cross, what I would ask is, it sounds like most of the morning is likely going to be taken up with the remainder of Ms. Willis's testimony as well as any additional witnesses from Ms. Merchant. And so perhaps we can use that time between then and then the lunch break to take a look and see if these sources are inaccurately cited. I mean, the characterization isn't something that's going to be determinative. I don't think I'm bound by whatever he describes as the event. But if this is just, I really don't see much of a substantive distinction between a demonstrative and a witness. But if he wants to put it up through a witness, and it's not something that you need to rebut with expert testimony of some kind, then I really don't see this as being much ado about nothing.
I'm sure you can understand why I couldn't agree.
Sure. No, that's fine.
Without having gone through that.
But I don't know if it's something that we need to bar outright until you've had a chance to look at it if you see some incredible inaccuracy in it or something like that. All right. Anything else from the state?
No, Your Honor.
Anything else from defense counsel? Let me go in order. Mr. Sadow.
One quick question. I understand the court had the bullet point where I was going to go. Do we need to put into the record the speech itself in the transcript, or is the court taking notice from what we've already filed?
I think it's extensively quoted in all of the pleadings. If you feel that's something that we need to have officially recognized, I think certainly we can do that. I don't know if the state has a particular version or a pleading that they want to double check for accuracy, or it can just be something that's as assumed as a matter of law as pleaded by defense counsel, and then we can make a ruling on it from there. But
there's certainly no certified transcript that I'm aware of. If they want to give me the version that they believe to be accurate, then I'll certainly take a look at it.
Okay.
I have a USB that my paralegal downloaded onto a USB drive to take home.
All right, and that's also not something I think we need to have done by tomorrow. I'm not going to be ruling on. Yeah, I mean, I'm not ruling on any of this tomorrow. I mean, this is something that's going to be taken under advisement on all aspects. So the forensic issue we can bring up, and we may need to bring everyone back if everyone needs an extensive, not even extensive, but if everyone just wants to be heard in argument in some way, we're probably not going to have time for that tomorrow either. So my hope is perhaps we can just close the evidence tomorrow, and we'll take it from there.
We're going to want to have argument, and I've already requested, depending on how busy the court reporter is between now.
Yeah, the answer is they're all busy, and we don't have enough of them. So
I don't know. This court reporter was giving me a potential of a reasonable time period, but is that what you just turned over to Ms. Cross? Does that also have a transcript,
No.
or is it just having video?
It's got the USB video. I believe that's all it is.
again, I think that's something I'll just wait for direction from the parties on. I don't think that's something we've got enough to deal with tomorrow, and I think we can handle that as it comes once we've had a chance to take a look. Okay?
So no arguments on the motion?
I doubt we're going to reach it if the state has 4 to 5 hours of witnesses and.
That's fine, just a question of preparation.
Yeah, I don't think that's going to be needed. Okay, Mr. McDougall.
Just a very short housekeeping matter. You ruled on Monday you didn't want to hear any evidence about the county ordinances and so
Sure.
forth. The statute 24-2-221 requires that they be put into evidence as opposed to being cited as law. So before the defense evidence closes, I would like to tender certified copies of those. I don't need a witness
Sure.
for that. And then I've got one other certified copy that I want to tender. I don't need a witness for that. So that would just be a little mechanical thing right before the defense evidence closes, Your Honor.
Understood. Any thoughts from the state on that? Okay.
As the representation, if that's what the exhibits are, then I'd consider it a proffer more than evidentiary, but that's fine.
Okay.
I didn't want to upset the court's expectations tomorrow when I did.
Okay. Well, Mr. McDougall, my expectation tomorrow will be that when I talk, I get to take prominence, right?
You're the boss.
Thank you, sir. Okay. Anything else?
Not in the state, Your Honor.
All right. We'll be in recess 9 o'clock tomorrow. Thank you all. Sorry?
Copies I would give you tomorrow.
You're going to give me ideas.